Your Honor, I'm here on a motion to set bond for Mr. Pierce. He's got 3 cases that are active, and if I can give you an overview, in 2018 CF 2647, originally he had received 48.9 months, followed by 120 months, 10 years of sex offender probation. The charges were extortion under 836.05, use of a computer to facilitate or solicit a child under 847.013 sub 3, and unlawful use of a two-way device to commit a felony under 934.215. Of note, when he was adjudicated in that case, it was a double jeopardy sentence as to count 2 and count 3. In 2024 CF 1948.
Sorry, Mr. Switek, what do you mean by that? It was a double jeopardy sentence.
Use of a computer to facilitate a child or solicit a child, and the unlawful use of a two-way is a double jeopardy.
I understand that, but was anything done about that? Or?
No.
Okay, you're saying that happened and it shouldn't have happened.
Correct.
Okay.
In 2024 CF 1948, recent case was failure to report a change in telephone number under 943.0435 sub 4E2. That's an open case that we believe will eventually go away or go to trial. In that case, he received a $2,500 cash or professional bond. In the latest case, 24 CF 2599, it's 3 counts of failure to register an email address or internet identifiers under 943.0435 4E2. Received a $10,000 bond on each count. Mistakenly, he was classified at first appearance in that case as a violent felon of special concern, and he does not meet the criteria of that designation.
That's in the most recent case that was determined?
Yes. And in that case, he did not get a bond for the VOP. That brings us to the issue of asking for a bond for the VOP in 2018 CF 2647.
All right. State's position.
The state is opposed to any bond in Mr. Pierce's case. When Mr. Pierce was placed on probation for his soliciting of a minor, extortion of minors, one of the special conditions is that he not have internet access or any devices capable of internet access. Your Honor, and also, of course, not break the law. So while he was on probation for offenses against children involving electronic devices, he gained the new failure to register, failing to register the phone number. But more significantly, Your Honor, the second new offense that he obtained while he was on probation is the fact that he did not register electronic email addresses that he was actively using. Your Honor, our concern is this came to light because they actually went and searched his home because they had intel, probable cause to believe there would be child pornography found at his home. And that investigation is still ongoing, but in the course of that search, they actually found devices capable of connection to the internet, which is a violation of his probation in his room, and I believe they were actually under his pillow or under the mattress, but they were definitely tied to him. So that violation of probation is significant because it is actually one of the safeguards that the court put in place so that there would be lesser danger of him contacting children again as he had previously. So, Your Honor, we believe Mr. Pierce has shown this court that he is not capable of being on community supervision and complying with the safeguards that the court put in place to protect the community. So we'd be opposed to a bond on that VOP.
Response, Mr. Switek.
No, Your Honor. I do believe he'd be entitled to. He's not disqualified from getting a bond. He has a stable residence, lives with his family.
Do you agree that his current probation says he's not supposed to have any sort of Part of my concern, and when I read this yesterday, is one of the things that was allegedly found in the newest case was a Snapchat account, which is what was used in the first case in 2018 in order to solicit the minor. So not only does he have a device, allegedly, in his possession that can access the internet, which is a violation of his probation, but he also has the same app that was used when committing the crime for which he's on probation.
But we don't know that, and that's not charged. It's alleged.
And probable cause was found at first appearance, right?
No, not for the Snapchat. Snapchat.
Your Honor,
Go ahead.
to perhaps add something to the court's concerns, in 24-25-99, one of the accounts is actually the Snapchat. So yes, Your Honor, Snapchat is actually in play in the register and is also basis for the violation of probation. And actually, I believe that's where the nickname came from for the child pornography as well.
I'm looking at the information, doesn't seem to indicate which particular Snapchat or Instagram or what, but I'm reading the arrest report from the first appearance in 2599, sorry, 24 CF 2599, where it talks about there was a Snapchat account on the phone that was found under the pillow. And there's previously been a finding of probable cause for that purpose. So, I've got some concerns here. I know it's not proven yet, Mr. Switek. That's,
And it's not alleged in the information.
information says failure of sex offender report, electronic mail address, or instant message name.
Right, that could be Facebook, that could be anything.
Well, I understand, but I'm reading the arrest report and it says that it's Snapchat.
Could be in the information then.
Your motion is denied, Mr. Switek.
Thank you, Your Honor.
Mr. Powell?
One for Powell, Trevon Bowman. He's going to appear by Zoom, Judge.
Oh, okay, well, no one had told me that, so let me get that started for you.
And it's 15 CF 1248.
That's
You are in the meeting now.
There we go. All right, Mr. Bowman, can you hear me okay?
Yes, I can.
All right, thank you. All right, Mr. Powell, did y'all file anything as far as his Zoom appearance? I know it's not your case, it's Bo's.
I thought he did, Judge.
Okay, I just hadn't seen anything, but just make sure that gets done in the future
Okay.
if it's going to be a Zoom appearance.
Thanks, Judge.
All right.
We've got an agreement with the state that he pays restitution in full, which he's able to pay now. He's in California.
Okay,
And then the PTI will be dismissed Pay and dismissed.
How much time is needed?
Yeah. Do you have the money now, Mr. Bowman?
Yes, sir. I called the clerk's office and they didn't have any record of this restitution. So I was told to mail a cashier's check today overnight.
And how much do you have? How much is it?
I did, let me check. Morgan texted it to me.
Judge, originally Mr. Bowman had entered a DPA agreement with the state. The state's offer to Mr. Powell as of yesterday was to do a plea and a PTI with the same terms. The restitution would be $2,474.74 to rent a center. But the state does want to get the plea and the PTI in the event that restitution is not paid. And this was communicated.
Well, is he prepared to pay the entire amount of the restitution now?
That's my
Are you
understanding.
prepared to pay it? Yes, sir. He's ready to pay it. He's got it. You have a cashier's check? Is that what you got, or have you paid it yet?
In any way that the state allows me to, I can pay it over the phone with a card payment. I can send a cashier's check, a money order, whatever is necessary.
I'd like to get the necessary documentation, paperwork signed, and then and I have no objection to him appearing via Zoom, bring him back, and we can ask that be paid directly to the clerk, is my intention, Judge.
So is the intention that if he pays it all, to still go on PTI? That's what I'm just wondering if, and I'm not
I'd
trying
like to just put that in place, since this is a 2015 case, Judge.
How has it been open since 15 on a DPA?
There was an FTA almost immediately.
I think he had some issues, Judge, but,
Failure to appear back in 2016. Right. Well, the problem is, is there a written plea agreement to a PTI? Is that what y'all discussed, Mr. Powell?
This is something that I've just been emailing with Mr. Powell just yesterday about, so we really haven't had an opportunity to get the paperwork signed. I haven't even drafted what I need to draft. This just came to my attention yesterday.
you want to,
I think we're going to need another date because he doesn't have the paperwork anyway.
Yes, sir. That's what I recommend.
Especially if it's going to be why
don't we do that, Judge, next earliest date you got, and we'll get the paperwork, whatever we need. But I thought you were going to dismiss it yesterday.
I'm not just going to dismiss it today, though. That is my intention, but I want to put everything in place, all the documents necessary in place.
Okay.
So that if there's any other issues and any more years of absences go by, we have it in place where he can be sentenced.
I guess it sounds like what Mr. Powell's saying. If you get if the restitution is paid before the next court date, are you still going to do the plea and PTI? Is that the state's offer? I'm not trying to encourage or discourage anything. I'm just trying to make sure it's clear.
If we can put it to where the clerk will accept it, if we can announce that it's the amount that it's payable to rent a center and that it's payable to the clerk, and if the clerk will accept it, then I can do that, yes. I just want to make sure that that's something we can accommodate.
Mail your restitution in now, Mr. Bowman.
Rent a center, and it was how much?
2,000. It's 2,474 and 74 cents.
247474.
2474.74. You got it?
All right, and there's a $3.50 surcharge from the clerk. Cut the check. So does he make one check for all of it? Didn't make it payable to the clerk?
Payable to the clerk of the court.
Wait, hold on. Don't tell him yet. I want to make sure that's right.
All right.
I'm just wondering if he sends the rent-a-center, it goes to the clerk, then do y'all just forward it to rent-a-center? Okay.
What do you want to do, Judge? Tell us.
When's my next court date? All right, right, why don't we put it on the February 24th date at 9 o'clock? If it gets resolved by then, obviously, that'd be fine. Otherwise, if it's going to be a plea, make sure we have all that paperwork in hand in advance.
Thank you, Judge.
The plea, the PTI.
February 24th, you got to
Fingerprints.
come back on Zoom. Okay?
All right. He can appear by Zoom if it's needed. But-
Correct.
All right. But just have Bo's office, I don't like to use first names either, but I want to make sure what I'm saying, instead of saying Mr. Powell, Bo's office contact us that he needs to appear by Zoom, so that way we bring it up and we're ready to go.
Got it, Judge.
Okay. All right. Thank you, Mr. Bowman. We'll see you back on February 24th via Zoom at 9 o'clock.
Thank you.
All right. Anything else, Mr. Powell?
I have Keith Golden Jr., 24 CF 2739, and 21 CT 2522. We want to combine those cases together, Judge, and we want to continue one time.
Actually, we want to run them together, Your Honor.
When is the new case set? I'm trying to pull.
Pretrial conference on Tuesday.
210.
$210.
I've got it on 224. The 24 CF 2739.
I could have the wrong date on the front of my file.
I've got it set for 224.
The state would have no objection to them running together, Your Honor. It's going to be a combined offer anyway.
Okay, so let's move the 21 CF 2522 over to the February 24th at 9 o'clock docket where the other one already is.
9 o'clock, Judge?
Say again?
9 o'clock?
9 o'clock, yes, sir.
That's all I have, Judge.
All right,
Thanks.
thank you. Good to see you, Mr. Powell. Ms. Dudley? Morning, Ms. Dudley. You've got,
I have Anterus Mclean, Your Honor.
okay.
21 CF 1484, 1192, and 2777. Your Honor, he's currently been held without bond on his violation of probation. He was currently on misdemeanor probation for 1 year of administrative probation. He picked up new charges in 24 CF 2829, possession of firearm by convicted felon, and possession of controlled substance. We have submitted to the state a statement from the person who owns the firearm. She stated she left the firearm in that room. He did not know it was there. It was not in plain view. And I believe the amount of narcotics was very small. If I remember correctly, it was less than a gram, I believe what law enforcement said, or approximately a couple grams or something like that. This is the case, I think we were here last week. I have requested those recordings in that case, as there's a lot of
All right,
confusion.
well, I watched it yesterday.
Oh, did you?
'Cause
Okay.
I can watch them anytime. From what I listened to, it sounded like it was supposed to be 1 year of DOC probation, even though it was administrative, because Mr. Berry stood up and said there's a one-time $50 fee for that. So I think it was supposed to be with them, not county.
There was an order later put in that I saw, Judge. So there was a lot of stuff done outside of that. So
Okay.
it was an order later put in that it was going to be JCS probation. So I was confused by that too. But anyway, he is asking for.
Well, which order? Because I see the order from July 3rd. All it says is, order that the judgment and sentence is amended to credit for time served followed by 1 year administrative probation, but that's all it says. It doesn't say
I
county.
saw it on one of the cases. I don't know if I printed it out. Let me see.
Sure, go ahead. If you can answer our question, Ms. Leone, that would be great.
I am looking at the order placing defendant on probation that is signed by Judge Gonterek on August 7th, 2024. And that states that it's ordered and adjudged that you're placed on administrative probation for a period of 11 months, 29 days to run concurrent between all counts for the offenses, and the listed offenses are felonies. Is the state's contention that this defendant did violate probation in a material way by committing and being arrested for a new law? Additionally,
Hold on just a second, just to answer the question we had initially. Number 7 in that order placing him on probation says report monthly to JCS. which is not what the announcement was at the hearing back in, let's see, June 27th. That's not what was said. Because I listened to it yesterday, because I recall you asking
Yes, sir.
about those things.
That's
So the judge said one thing, the order says something different.
Gotcha. And he's been saying that. He's
Which
been
is
saying that's
probably
been-
why there's been a confusion about it.
That's been the issue, and some other issues dealing with the plea itself, and I have to look into it. But he is asking for a bond to be set based on the fact that he did not have that firearm.
Okay.
And the amount of narcotics that were found were, I think, less than 1 gram of controlled substance.
Okay. Well, it's still a violation of the law.
I understand.
Right? Okay. Ms. Leone, you can finish. I'm sorry. I saw that and I wanted to bring it up because that was the question I had, because I hadn't seen that in the order until it was just brought up.
Yeah.
Your Honor, it's the state's position that independently from the misunderstanding, one thing is clear, that he was on probation, even admin probation, with the requirements not to commit any new law violation and testify truthfully for the state at a later date. I want the court to know that his prior criminal record includes burglary of occupied dwelling, which is a second-degree felony, and also a robbery. Those two charges in his past record will qualify him as violent felony offender of special concern, and according to the statute, is not to be released on bond pending the resolution of the violation of probation. So the state requested Mr. Anterus Mclean be held without bond.
Response, Ms. Dudley, once you've finished talking up with
Yes, sure.
McLean.
Your Honor, my response is still the same. I understand they're arguing that and I understand the court has listened to the recording. There's a lot of behind-the-scenes stuff that went on that I will deal with at a later date if that's what I need to do. Based on what he's told me, we still are asking for a bond being set in this manner.
If he's got priors that would make him a violent felony offender of special concern, how do I give him a bond?
What he's telling me, he believes he's on probation for misdemeanors. You guys are saying it was felonies. The plea agreement said he was getting time served for 3 years DOC, the written plea agreement. So I understand the court's position. I will just ask for leave to refile if I need to, once I get everything I need in the case.
Sure. All right. Based on the violent felony of special concern, and he's alleged to have committed a new law violation while on probation, I'm going to deny the motion without prejudice. If you need to bring it back, I want to say this specifically because the concerns with a second bond motion, whether or not there's a substantial change in circumstances,
Understand.
that you can still bring it if you're able to pull those recordings and there's something different. Like I said, I went back and watched the June 27th date. I didn't go back to what he was initially
Yes, sir.
supposed to be given, but there's clearly some confusion. He was supposed to be on administrative probation, but I think the court, and this wasn't me, but I went back and listened to it, announced DOC acknowledged, state probation acknowledged that. I think the order is just wrong.
Okay.
But obviously, if you want to bring something back to my attention, I'm fine with that. Just based on what I've seen so far, this is
Yes,
what
sir.
I've got to do.
Thank you.
That's all I have, Your Honor.
All right, thank you, Ms. Dudley.
Nicholas Court.
Yes, sir.
Good morning, Your Honor.
Morning.
Gilbert Schaffnet, Gainesville, Florida, on behalf of John Forrest. This is a remand, Your Honor, from the first ECA on a 2010 case. Judge Gonteric has been assigned to it. I actually have been sitting in his courtroom and heard the word petition and knew I was in juvenile court.
I don't see it on my docket today.
It was specially set to allow us to file a motion to dismiss under Smith v. Arizona case that came down from.
Can you give me the case number?
Sure, yes, sir. It is 2010 CF 000057A, and it's been handled by Mr. McGraw out of Pensacola. I don't know if anyone
This is
is.
the state attorney.
Your Honor, Mr. McGraw is not currently present. This was once my case many, many years ago, but I do know Mr. McGraw is handling this case.
Okay.
I can reach out to him if I need to.
we'd be asking for a new date to allow Mr. McGraw's office to see if they want to traverse the C4 or.
When was that filed?
I've been on the road about 3 days. It was probably about 3 days ago.
Okay, no problem. It's just, it wasn't listed on my docket, otherwise I would have read it. So if he needs time to do that, I would certainly give him time. I hate that you drove all the way over here from Gainesville.
It's not a problem, Your Honor. It was passed the last time because my co-counsel and I came down with the same thing, and
I remember reading that.
yes, sir.
Okay.
So if we could
You want
just,
to put it on a motion date?
that'd be fine, Your Honor, I think.
I think that will be, and I will let Mr. McGraw know the date, Your Honor, if there's any concerns, Your Honor and counsel.
That'll work.
What would work better for you, afternoon or morning?
Afternoon, since it's about a 5-hour drive.
I've made it a few times. I was a baby prosecutor there
Okay.
once. You probably beat me up a few times, Mr. Schaffner. March 27th in the afternoon, 2 o'clock?
That'll work, Your Honor. And Mr. Forrest is released on bond and ankle bracelet. His appearance has been excused, so.
Okay.
And that's all I have,
All right, thank you.
if I might be excused.
If you, just to make sure I get a chance to read it, could you courtesy copy of the
I will to
motion
your
my
office.
I'd like to read it. I'm not sure what it's about, but
Absolutely.
I'm always curious.
There's a long history of motions and hearings.
2010 case, I would assume so.
Right.
So-
Thank you.
All right, thank you, Mr.
Thank you.
Schaffner.
If I might be excused?
Yes, sir.
Thank
Safe
you. Do I need
travels.
to sign anything?
No.
Okay, thank
We
you.
don't do that here.
Thank you.
All right. Okay. That's- All right, Jessica Fickett. All right, are you Ms. Fickett? Yes, sir. All right, Ms. Fickett, you're here on a violation of probation in 22 CF 2574. Can you afford an attorney to represent you? in this case?
I filled out the form for the
Public
indigency
defender.
form at
Okay.
the beginning of the week, so I'm waiting on that.
Get in there yet, but I'll go
It was
ahead and
Tuesday.
provisionally appoint the public defender for you. But obviously, if they get the form
Yes,
and
sir.
process it, and you don't qualify, then, they may withdraw from your
Yes, sir.
case. All right, who would have an F case? Is that,
It's my case, Your Honor?
no, I mean for
Oh.
the public defender.
Who's got it over here? You want me to just give it?
Are we, Mr. Russell, are you still taking the front half of or the front part of the alphabet? Fickett, 22 CF 2574, the VOP.
You can put it down as Mr. Gibbs for now. We'd go ahead and enter a denial on the VOP and ask for a court date down the line so we can get a chance to meet with her.
May I place the offer on the record, Your Honor? Just,
Go ahead.
the offer would be to revoke and terminate and a new term of 2 years community control with the same conditions.
Judge, at this time, we're still going to deny. Ms. Fickett wants to meet with us, and so we can go over everything.
That's fine. March 27th at 9 o'clock. Obviously, if y'all decide to take the plea or you work something out, you want to try to get it in earlier, you can certainly put it on the sooner docket.
Thank you, Your Honor. That's fine.
Was there, do I have Walter Saga Piper? All right, no, he's an adult, so. Otherwise, we're going to think you're a lawyer and hold you to those standards. All right, Mr. Saga Piper, you're here in 2020 CF 2802. I believe this was a motion for early termination of probation, correct?
Yes, Your Honor.
Okay, what's the state's position?
Your Honor, the state is not going to recommend and it's going to object to early termination given the nature of the charges and also the letter that the probation office sent. Also,
Go ahead.
not asking for a termination for the same reason. Because of the charges, I don't believe it's done at least 80% even of the probation term. And
Hold on just a second. You said there was a letter from probation?
yes, it was, Your Honor, it was attached in a chain correspondence via email. Your assistant was copied on it. I can retrieve it if you wish. One second. Attached here.
All right, here it is. Okay. All right, Mr. Sanago, tell me why I should terminate your probation early. I've reviewed your letter that you filed as part of your motion.
Yes, sir. May I just have a moment to address the courtroom?
Go ahead. If it involves reading the letter, don't worry about doing that. I've already read it.
Oh, okay.
But if you want to tell me something, you can certainly tell me anything you want. I've reviewed the letter in advance.
Okay.
Go ahead.
I'd just like to thank you for taking a moment of your time today, and
It's my job. It's okay. Thank you.
I just hope that, all things considered, I'm eligible.
Was it 5 years or 6 years?
I believe it's 6 years.
Oh, okay. I can see it now. On one of the things, the counts are out of order. It's 1, 3, 2 instead of 1, 2, 3. So that was throwing me off for a second. So that's why I'm just trying to make sure I'm tracking it. So it was 6 years basically on count 1, which is the home invasion, and then count 2, since it was a third-degree felony of carrying a concealed firearm, was only 5 years, and then count 3 was 1 year for the misdemeanor. which was youthful offender as well.
Yes, sir.
Anything else that you want to tell me, Mr. Sinaga?
I did write a closing statement.
Okay, if you want to, just tell me what you'd like to tell me, but I just want to make sure you knew you didn't have to read the letter because I've reviewed it already.
Oh, yes, sir.
Go ahead.
Your Honor, I've shown through my behavior, achievements, and dedication to my personal growth that I'm no longer a risk to the public. Probation has served its purpose in my life, and I'm ready to continue being a productive, law-abiding member of society without the constraints of supervision. I respectfully ask for your consideration of my request of early termination.
Anything else from the state?
No, Your Honor.
All right, so Mr. Sinaga, you were sentenced as a youthful offender by the court, correct?
Yes, Your Honor.
Okay, so that takes it out of the normal kind of sentencing scheme that we use. Had that not been done, you pled to the court on a first-degree felony, which has a possibility of life in prison as a level 10 offense. That alone scores you significant prison time had you gone through it that way. It's also my understanding that you pled straight up to the court. It wasn't me, it was one of my predecessors who gave you this chance of youthful offender, and you've done very well. However, 6 years of supervision for something that could have got life in prison is pretty lenient to start with. And how old are you now?
I'm 22.
Okay. One of the reasons, and I used to argue this when I was a defense lawyer all the time when I was trying to get youthful offender in a situation like yours, is the reason we have youthful offender is because despite being an adult at 18, biologically, chemically, we're not really who we're going to be until we're about 25. Okay, the human brain, especially in males, doesn't really finish developing until 25. And so that was always the argument that I used to make, is that, people of a young age have difficulty sometimes with their decision-making process because they're not fully cooked yet. And so still being 22 years old, you're not even really to that point still. You've done everything you're supposed to do while you've been on probation, and I'll certainly applaud your efforts and that you've turned your life around. But I think keeping you on probation for the duration, and I'm not saying I wouldn't entertain something going forward, but I think the 3 years probation basically for these types of charges, and I've read the reports as well as to what the allegations were that you pled to, are pretty serious. So although, again, I think you've done well, I think supervision is still needed.
Thank you.
All right, thank you, sir.
Your Honor, if I may.
Go ahead, Ms. Rivers.
Page 28 on probably the next to last docket that came out. That would be Lisbeth Velez Sagara, 24 CF 1365. It was set today for a restitution hearing. And Your Honor, she is present and approaching. We have reached an agreement in this matter, Your Honor. Restitution in the amount of $2,322.50.
That's correct.
State's agreement?
Yes, sir. And
And
that's
that's payable to?
Michael Angel.
Okay. All right, restitution will be determined by agreement, $2,322.50 to Michael Angel. And she was placed on probation, correct?
Yes, Your Honor.
Okay. So make sure you talk to probation on your way out, ma'am, just to make sure they're clear with you, and, because usually there's a kind of a payment plan that gets put part of restitution.
Well, excuse me.
Go ahead.
I've been paying restitution already as it is since the last time we came.
Okay.
Her probation officer in the county she lives in had
Yeah,
already got
so
her
I-
started.
What county is that?
Sir,
What county is that?
I live in, Mariana, Jackson County.
Jackson County.
I just moved there, so
All right.
sorry, it took me a minute to
No, it's okay.
realize.
I just want to make sure that that information is getting back to our local people.
Okay,
Because,
so that will be added into the probation.
yes.
Okay.
Well, restitution was previously ordered. We reserved the amount of what it was going to be. Today, we're determining that amount based on agreement, which, at that 2003,
Okay, that's completely fine.
But it's part of your probation.
Yeah, I'll take care of it.
I understand.
Okay,
You're
thank
ordered
you.
to. Thank you.
All right, have a good day.
Just make sure you talk to probation before you walk
Okay,
out.
I sure will.
All right. Did y'all have anything else you wanted to bring up? Or should I just start at the top? Ms. Flowers, are you ready? All right. All right. Mr. Russell, Mr. Williams.
Sir.
Bueller.
Judge, I've got Cody Hinley. He's here for a status on, well, actually, I think I had him scheduled for a competency hearing. He does not answer, and I note that I don't believe the lady who took over Mr. Barnes's spot is here either. If we want to pass her, I can maybe try to get this still put together. We had him reevaluated, and our position is that he's now competent.
He is?
Yes, sir.
Right. But he's not here.
Yes, sir.
You want to pass it to see if?
Let's pass it until this afternoon. Let me see if I can get him in for the 2:30 docket.
Just make sure you bring that back up, Mr. Williams.
Yes, sir, I will.
Anyone else have any cases to call?
I've got one other out of custody judge that I can call. Dakota Josie.
You have the jail people here?
I am, Judge. Judge, with regard to Mr. Josie, he's trying to get into a facility. They're dealing with the insurance right now. The facility is Banyan Treatment Center. The address on it looks like it's Gulf Breeze, and I've had communications from a Jacob Gilbert who's with that facility twice on the situation of trying to get him in. If we can pass him one more time, at least we should be in a position where he's in that inpatient facility and we can figure out where to go from there.
Okay, and this was 23 CF 1095 and 1330. Ms.
Yes, sir.
Turner, you're standing. I'm assuming this is yours?
No, yes, it is mine, Judge. I was just going to say no objection.
Okay. So it'll be March 27th at 9 o'clock, Mr. Josie. Obviously, if you're in a program and it's difficult to get you transported over here, I'll certainly entertain that you can appear by Zoom if that can be done through the program. Just make sure you stay in touch with Mr. Williams so he knows what's going on and can file the appropriate paperwork.
Yes, sir.
All right. Thank you, Mr. Josie. We'll see you back then.
Yes, sir.
Thank you, Judge. Everybody else I've got is in custody. Okay. Judge, I had already asked Dr. Zeman to go and evaluate her as of her last court appearance. Having dealt with her in the past, I just felt like an evaluation would be something just to cover the bases that would need to be done.
Okay.
In her last court appearance, I now feel like that's just plain necessary.
Yeah. Has it not been done?
And so what I'm going to suggest is, since we've already reached out to Dr. Zeman to have her evaluated, I'm going to hold off on doing a written order, hoping that she'll go ahead and cooperate. The order would really be directed at Ms. Hegland to make sure she cooperates with the evaluation.
All right, so Ms. Hegland, they're going to have a doctor come and talk to you, but I need you to make sure you cooperate with that. Do you understand? Ms. Hegland,
I hear, but I do not.
say again.
His bond was denied.
Ms. Hegland, I'm asking you a question.
Dad,
That a doctor is going to come and talk to you. Are you going to cooperate with that?
I'd love to hear what he has to say.
Okay. Well, make sure you answer his questions, okay?
For certain.
Because the sooner that gets done, the sooner we can move on with your case, one way or the other. So make sure you talk to him. Does doctors even do them in person?
Yes, sir,
He does? Okay. All right. So make sure you talk to him when he comes to see you. What are we here for? Is this a new case?
It is, Judge.
What do you want to put it on? 226, basically?
Yes, sir.
All right. 226 at 9 o'clock.
Thank you, Judge.
All right, we'll see you back then, Ms. Hegland. Make sure you talk to Dr. Zeman.
Mr. Johnson? Judge, I spoke to him at the jail, well, no, wait a minute. He's out because he went to drug court yesterday and was intaked into drug court.
Okay.
So he should be off of our docket.
Your Honor, I believe he pled into drug court on Wednesday.
Okay. So we don't need anything for that?
No, sir.
All right. Joshua Johnson, drug court.
All right, Judge, this case was passed. Mr. Judy had asked that I figure out his credit. I did that and announced it. I think the state was wanting to confirm that. And in conversations with her, I think she's...
The state is willing to stipulate that he received credit for all time served and stipulate that that includes a calculation from the date of his hold in Georgia of August 29th, 2024. And that hold was in both cases. As far as stipulating to a specific number of days, I would prefer to have the jail do that credit award, since that's more their lane than it is mine.
Judge, it may be that there's been newer case law out on it, but it used to be that the court was supposed to announce credit. We normally don't do that because it's easier for the jail to calculate it. But I provided the court with, and can provide, I think it's written actually on the original plea agreement. The court may still have the original signed agreement, Judge.
When do you think that was filed?
I gave it to the court when we were in court last time, and I don't, and then it was passed.
I don't hold on to those things.
I didn't sign it. I think that was why we put it on for today. So
Okay.
Oh, I'm looking at the wrong file. Wait. Here we go. All right, Judge, this is Judge, I can just attach this to it and have him re-sign it. I do not have the one that I gave to the court last time. At least I don't see it in the file. What I see in the file is my copy. And then I'll attach my sheet with my calculations on it. All right, I'm going to need you to re-sign it, or do you want to wait Judge, what I think he's wanting is for the court to announce the credit it's going to give
Well, here's the
before he
thing.
decides.
I don't know what the credit is, so do y'all agree on what the number is? Otherwise, you gotta give me some sort of evidence as to what it is.
I think what I'm hearing is that the state's not agreeing.
Okay. Well, I think she's just saying she doesn't want to agree to a specific number.
Correct.
So I think you need to tell me why you think it's a certain number if you want me to announce anything.
It'll be easier if you have this sheet, Judge.
Okay.
He has two different cases. All right, I've gone through the clerk's file on both of those cases, and here's what we have. The case number ending in 2053, he was arrested on 2/29/19 and released on his own recognizance on August 2nd of 2019. His bond was then revoked on August 12th of 2019, and he was sentenced on September 26th of 2019. There is a sentencing credit memo in the clerk's file, filed contemporaneous with that sentence, that gives him credit for 209 days. So that seems to be already judicially determined. He was then arrested and held in McDuffie, Georgia on our hold, and the state stipulates to the hold on 8/29/24. And then when he was transported to our jail, he was arrested there on October 21st of 2024. And then the proposed sentence date today is 2/6/25. So from 8/29 to 2/6/25 is 166 days. If the court were to go from the later figure, it'd be 108 days. We're asking that the court go from the date of the hold, and the state seems to agree to the date of the hold. So the total credit using the 8/29 hold date on that case is 375 days, consisting of 209 days plus 106 days. Now, in the later case,
166 days.
I'm sorry?
You said 106, it's 166.
166, I'm sorry, Judge.
It's okay.
It's 166.
I just, when these numbers seem to be the most important thing we're talking about, I want to make sure we're saying everything properly.
Yes, sir. All right, on the case number ending in 3152, that's the newer case. He was arrested on that case, according to the clerk's file, on November 19th, or November 18th of 2019, and was sentenced on...
All right, so basically you're saying you want me to give him 375 days on 2053 and 321 days on the 3152.
That's correct, Judge. 375 on the older case, and then 321 on the newer case. And the clerk's file is the basis for the credit.
Okay. State want to give any position on that?
No, Judge, we defer to your judgment.
Okay. And what's the agreed upon sentence now?
15 months, Department of Corrections.
That's correct, Judge.
All right.
Let me get your signature again on that.
Mr. Judy, you understand that if you've got more credit in one than the other, you're still going to do whatever is the balance of the, you say 13 months minus the 321 days?
15 months, Judge,
15
minus
months, I'm sorry.
Yes, sir.
I can't give you credit in one case that you would have had in the other.
So, what is it?
You have more credit on the older case because it's older.
Yeah.
Okay? So what's going to control when you get out of jail is going to be the newer case.
So it's not getting, I'm still going to have...
You're going to have...
321 days credit off of 15, plus whatever gain time they give you, which I can't tell you.
Yeah.
I know what, you know what the rules are probably just as well as I do, but I can't guarantee anything like that. In fact, that's part of the plea agreement where, your lawyer, the state attorney, and the court have not told you what kind of gain time you're going to get or any actual sentence you would serve.
I was just kind of wanting a ballpark figure of what I got.
Well, you're going to have 321 days taken off of that 15-month sentence. And when we met, I calculated 15 months at 30 days per month, and we talked about the fact that some months have 31 and some months have 28. And so we were just talking about a ballpark figure.
That was 4 months, right? Would have had left somewhere in there.
I don't remember off the top of my head, sir.
Something like that.
All right, so are we going to enter the plea or not?
Yeah.
These are the kind of things that could be talked about a little bit more outside
And-
of the court's presence.
And actually, they were, Judge.
I understand. At some point, we have to make a decision, Mr. Judy.
Yes, sir.
Ms. Turner?
I just have the score sheet.
And it may actually be that you've got my original plea agreement.
I do not have it, I know that.
No, I meant, I may have given it to the state for her to sign back when we had court last time. I'm thinking that's probably what happened. I'll give you this. Okay. Okay. I came up with it. Sure.
All right, thank you.
Show the judge the minute she from
All right, Mr. Judy, can you raise your right hand? Mr. Judy, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sure.
All right. You've gone over this plea agreement with Mr. Williams? Mr. Judy, if you could keep your eyes up and speak to me. You're kind of putting your head down. I can't really hear you.
Yes, sir.
Okay, you can put your hand down. You're fine, but keep your head up so I can hear you. If you go like that, I'm not going to be able to hear you. All right. You're here in 19 CF 2053 and 19 CF 3152 with a violation of probation. Are you under the influence of any alcohol, drugs, or controlled substances? Do you have any mental health diagnosis or concerns? Did you have enough time to speak with Mr. Williams about your case and this plea agreement?
Sure.
Okay. And did you understand it and sign it? All right. And it calls for you to get 15 months DOC with the credit that we've talked about. All right. And did Mr. Williams answer all of your questions if you had any? Okay. What do you mean you believe so? Did he or did he not?
Making sure that I'm getting the, yes, you did.
I understand you're very concerned about your credit, but you've got to answer the questions that I'm asking you.
Yes, sir. It's, just for the last year, man, I've already done like 13 months in county jails, you know what I'm saying, from Mississippi to here. And it's been kind of good for me because at the time I was on drugs and stuff like that. But I'm just trying to figure out how to get back to my kids. So
Well, I understand that, sir, but I only have control over my cases. All right. So whatever time you did in Mississippi or anywhere else, or Georgia, I think I saw another one.
Sure.
So I don't have any control over that. The only reason we're talking about credit for the time you were there is because we had a hold on you and we were trying to get you back here.
Yes, sir.
All right. So again, did he answer all your questions?
Yes, sir.
Are you satisfied with his advice and representation? Did anyone force, pressure, or threaten you in any way? Did anyone promise you anything in return for your plea? All right. And you understand by entering an admission to your violation of probation, there won't be an evidentiary hearing where the state would have to prove that you violated your probation. You understand you're waiving all potential defenses that you may have. All right. You understand that this would also make you a convicted felon if you're not already.
Sure.
Okay. All right. And what is your plea? Are you admitting or denying your violation of probation? Okay. I'm going to accept your admission to the violation of probation, revoke and terminate your probation, adjudicate you guilty on both cases, both single counts in each. Sentence you to 15 months in the Department of Corrections, concurrent with credit for time served since that date of hold from Florida, which is the August 29th, 2024 date, which is what gets
Georgia.
Say again.
It's, I believe, McNab County, Georgia.
McDuffie.
McDuffie County.
I understand. I'm reading what you wrote.
Oh, okay, Judge.
And it says the hold from Florida. What I think that's saying is
Well,
the hold.
Florida is the one that, I'm sorry, Judge.
All right.
I was just trying to explain it, I'm
It's
sorry.
$100 cost of prosecution, $100 or $150 PD fees. This is a guideline sentence of 15 months. Anything else? Credit for time served?
Yes, sir, no, Judge, nothing further from the defense.
All right. All right, thank you, Mr. Judy.
All right.
Outstanding money's got to collection, Chairman?
Yes, sir. Thank you, Mr. Berry. And then you'd be fingerprinted, Mr. Judy. You have 30 days to appeal the judgment and sentence of the court.
Read that. Judge, Mr. McNab was in county court when I went to see him yesterday.
Okay.
So if, let me just give him some information real quick. All right, Judge, I had, he wants to go ahead and enter a plea today.
Okay.
Let me see if I have that already drawn up. Okay. Judge, give me a second to draft that up for him. If we can bring him back later on this morning, I'll have it drafted up in a
See
couple
you
of
in a little
minutes.
bit, Mr. McNabb. He's just going to draft that up and have you take a look at it, and we'll get it resolved this morning.
Yeah,
if that's what you
just be
want to
later
do.
today. Okay? Judge, I went out and saw Mr. Moore. I'm not really sure why he's on the docket. It's a regular case that was passed
I
for
literally have
today.
a question mark on my docket next to Mr. Moore.
When I went out and talked with him yesterday, he's indicating he may wind up hiring private counsel on this
Okay.
anyway. So let's put him back on the regular docket.
Mr. Moore, was there something you thought we were supposed to be here for today?
I just kind of blindsided me, sir.
I mean, was it because you talked about possibly getting other counsel?
No, sir, I didn't talk about that till yesterday.
Where would you like to put him for now, Mr.?
For now, let's put him on the 24th, I guess. And I've already explained to him that if he's going to hire somebody else, he needs to go ahead and get on that.
Yeah.
We'll put you on the next pretrial date, which is February 24th. If you remain incarcerated, it would typically be the 26th. We're trying to spread out the dockets a little bit more.
Yes, sir.
Because the last time we were here till almost 7:30.
Yes, sir, I remember.
Yeah, so we're trying to not do that to everybody. So incarcerated people would be on the 26th, just so
Yes,
you
sir.
understand that.
And my family's supposed to be looking into hiring me another attorney.
Okay, well, if that happens, then that person will be here for you at that
Yes, sir.
point. All right, thank you, Mr. Moore.
Thank you, sir.
Thank you, Judge. Judge, that's all I have. I'll start crafting that fit.
Okay. Get Mr. McNabb going. Ms. Rivers.
Riley? Miss Riley. Oh, okay. Riley, yes, sorry. I got that stuck in my head. My apologies. Okay. Your Honor, this is Calvin Riley. He's before the court on 22 CF 295. We've reached an agreement in this matter, if I may approach.
Yes, ma'am. Thank you. This calls for 2 years community control, but he scores, so it's a plea bargain for downward departure?
Yes, Your Honor.
All right, Mr. Riley, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, and you're here in 22 CF 295. Can you state your name and your date of birth, please?
Alvin Cavius Riley, 11.
All right, Mr. Riley, you're here on a violation of probation in both of those cases. One where you're looking at a possible maximum sentence of 15 years, the second one 5 years. Obviously, we're not talking about that today, but just make sure you understand that. Okay. Did you go over this form with Ms. Rivers? Did you understand it? Did you sign it? Did she answer all your questions about it if you had any?
Yes, sir.
Are you satisfied with her representation and advice? And are you under the influence of any alcohol, drugs, or controlled substances? Any mental health issues or concerns? Anyone promise you anything in return for this admission to your VOP? Anyone threaten, force, or pressure you in any way? You understand by entering admission, you're giving up your right to an evidentiary hearing where the state would have to prove that you've violated your probation by a preponderance of the evidence? Okay. And how far have you gone in school, Mr. Riley?
That's
Okay.
cool.
All right, and are you admitting or denying your violation of probation? Okay, I'm going to accept your admission as freely, voluntarily, knowingly given. Modify your probation to 2 years community control. Waive cost of supervision, $100 cost of prosecution, $100 PD fee. Complete any previously imposed conditions that you haven't finished. So everything you were supposed to do under the original probation, you still have to do, but you're going to be on community control. Do you understand that? All right, so you got a little more intense. Any concerns or questions about that? All right. I'm going to also calls for an adjudication if I didn't already say that.
And Your Honor, would the court consider continuing to waive the cost of supervision?
I think I said that. It was on here. Looks like it was part of what was whited out at some point, but it's on there. So waive the cost of supervision as requested and previously stated. And then you've got 30 days to appeal, Mr. Riley, the court's judgment and sentence. And that means you get fingerprinted on your way out, and but you're going to talk to probation first.
And Your Honor,
Yes.
it's just a little bit longer than 2 years left, so it's just the next 2 years on CC.
The next 2 years, I was going to ask that, and then I didn't. So the next 2 years are on CC, and whatever the balance was will be just regular probation.
Thank you, Your Honor.
All right, thank you.
Mr. Riley? Haven't seen it.
Your Honor, this is Kyle Smith before the court on 23 CF 1667. We've reached an agreement in this matter. If I may approach.
You said Kyle Smith?
Yes, Your Honor.
Okay, thank you. All right, Mr. Smith, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you're here in 23 CF 1667 on a violation of probation for a third-degree felony, which means your maximum would have been 5 years in the Department of Corrections, but I've got a plea agreement which looks like revoke and terminate 9 months jail.
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right, can you state your name and date of birth?
Kyle Smith, July 10th, 1992.
Okay, and did you go over this form with your attorney, Ms. Rivers?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did she explain everything to you and answer any questions you might have had? Are you satisfied with her advice and representation?
Yes, sir.
Are you under the influence of any drugs, alcohol, or controlled substances?
No, sir.
Any mental health issues or concerns? Anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for the plea?
Sir.
And you understand by entering admission to your violation of probation, there won't be an evidentiary hearing where the state would have to prove how you violated your probation? Okay, and you understand you're waiving any potential defenses that you may have had?
Sir.
All right, and are you admitting or denying your probation violation?
Admitting.
All right. I'm going to accept your admission as freely, voluntarily, knowingly given in 23 CF 1667. Revoke and terminate your probation, 9 months, Okaloosa County Jail with credit for all time served, $100 cost of prosecution, $100 PD fee, $50 application fee. How we want to handle the fees? 90 days? Well, how long does he, I don't know what his credit is.
90 days upon release?
Okay.
I can do that.
All right. 90 days upon release. Now, if you go to the clerk's office, they can set you up a payment plan. Just make sure you do that before the time runs out.
Yes, sir.
All right. All right. Otherwise, adjudication and guilt. Step over, be fingerprinted. You have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
Is it going to be me or someone else?
Who was next, Ms. Rivers?
Your Honor, that would be Cheyenne Dow.
Dowell with a D?
Yes, Your Honor, D. 24 CF 2538. Your Honor, we've reached an agreement in this matter. This is going to be a pretrial intervention agreement, which is requiring a plea.
Yes.
Is there a plea form or is it just the pretrial intervention agreement?
Just the pretrial intervention agreement, Your Honor.
Ms. Dowell, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you just pull that microphone over to her, Ms. Rivers? Just the mask, I want to make sure it's picking her up. I heard her, but I just want to make sure.
You just get a little bit closer to it.
All right. Well, your name and date of birth, ma'am?
Cheyenne Dow, February 25th, 2005.
2005. All right. You're here in 24 CF 2538, charged with battery on a person above the age of 65. Do you understand that?
Yes, sir.
All right. I've been handed a pretrial intervention agreement, but the state's asking you to plea to the charge, complete the PTI agreement, and if you do so, the case would be dismissed. Do I have all that right?
That's correct.
Okay. I just don't have a plea form. Just want to make sure that everyone's on the same page. All right. So, Ms. Dow, what that means is if you don't complete the PTI agreement, say you commit a new crime or you don't do the things that you're supposed to do on this PTI agreement, that you'll come back and be sentenced by the court. Do you understand that?
Yes, sir.
All right. And this is third-degree felony?
Yes, Your Honor.
Okay. So that means I can sentence you up to anything, including up to the maximum, which is 5 years in state prison. Do you understand that?
Yes, sir.
Doesn't mean I'm going to, but I just want to make sure you understand that that's a possibility. Okay, you understand that?
Sir.
Okay, you just have to say it out loud. I can see you nodding, but the microphone can't pick that up, and that's what keeps the record for us. All right, so Ms. Dowell, have you gone over this pretrial intervention agreement?
Yes, sir.
Okay, do you understand that by entering a plea to this, you're giving up your right to a trial?
Yes, sir.
Do you understand you're giving up the right to confront and cross-examine witnesses against you?
Yes, sir.
You understand that you won't have a chance to call any witnesses on your own behalf?
Yes, sir.
All right. Do you understand that you won't be able to put on any sort of defense if you were to come back unsuccessful on this agreement, if that were to happen, that you won't have a chance to put on your witnesses and your defenses?
Yes, sir.
Okay. You okay with that?
Yes,
Are
sir.
you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any mental health issues or concerns?
Not as of right now.
Okay. Are you on any sort of medications for that?
No, sir.
Did you read this agreement and understand it?
Yes, sir.
Okay. All right. Did you go over it with Miss Rivers, your attorney?
Yes, sir.
All right. Did she answer all of your questions?
Yes, sir.
You had any? Are you satisfied with her representation in this case?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right. And how old are you? You said 20. You were born in 2005?
Yes, sir.
So you're what, 19?
Yes, sir.
Okay. And how far did you go in school?
9th grade.
9th grade. Were you able to read this agreement?
Yes, sir.
Do you have any questions before I accept your plea?
No, sir.
Okay. And what is your plea?
No contest.
I'll accept your no contest plea is freely voluntarily knowingly given. You're going to do the pretrial intervention agreement. I've been handed that agreement in addition to the regular standard conditions of it. You're going to participate in any programs established by the Department of Corrections for your supervision, including mental health, drug or alcohol counseling, waive cost of supervision, $150 in cost of prosecution, $967 in court costs. There'll be a substance abuse evaluation. The letter missing. And any recommended treatment, random urinalysis for the detection of any drugs or controlled substances you're not prescribed. No violent contact with the victim, which means you can have contact, but you can't be violent towards that person. Do you understand that?
Yes, sir.
Okay. Anything else that I've missed?
No, sir.
Very good. Okay. Does she need to meet with you?
Yes, sir.
All right.
We need the agreement, and we'll take that agreement, send her to our office. Once she signs that, we turn around and e-file it back to the court.
Okay. You want to come on up, Mr. Berry? I'll give you that. All right. Ms. Dowell, you've got 30 days to appeal the judgment and sentence of the court. It's violent. It's a battery. But it's a plea. I think you have to do it since it's a plea. Otherwise, I would guess if she came back as unsuccessful, she could say, well, that wasn't me. You don't have my fingerprints to prove I was the one that was there when it happened. Flores?
Charles Russell, Public Defender's Office. Judge, this is Terry Flores. Case number is 24 CF 1192. If I could just have a second. Judge, Ms. Flores has a case pending in misdemeanor court for the clerk. The case number is 24MM4346. We've reached a plea agreement on the violation of probation. I also have a copy of the minute sheet from misdemeanor court day before yesterday where Judge Ward said it's okay for her plea to time served.
I actually ran into Judge Ward this morning on our way in, and he told me about, I think there's a couple of cases where this is the issue, but
yes, sir.
He gave me carte blanche to do whatever I want with this case.
Well, I'm going to bring you the paperwork, and then if you've got any questions, let me know.
But we talked about it.
Good.
All right, Ms. Flores, can you raise your right hand and be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, so you're here in 24 CF 1192, but we're also handling 24 MM 4346, which is in county court.
Yes,
And
sir.
Judge Ward said that's okay if we handle that here. All right, so in 24 CF 1192, you would be entering a plea to burglary of an unoccupied structure, which is a different, lesser offense than the burglary of an occupied dwelling that you initially were charged with. Do you understand that?
Yes, sir.
Okay. And that's why we have all sorts of changes to the score sheet. I just want to make sure that's clear on the record. Is this what you want to do today?
Yes, sir.
Oh, wait a minute.
This is a VOP, Judge.
I just looked at that and then realized it was initially on the score sheet. That's why I thought it was a new charge. So that's, usually that's not changed. No, it's okay. I just want to make sure I got it straight, but you guys always need to correct me when I'm walking down the wrong path there, but I appreciate it.
Will do, thank you.
All right, so this is actually a violation of probation, Ms. Flores. I got that wrong. I want to make sure I cleared that up.
Thank you.
That you had already pled it down to occupied structure previously. And as well as there was a grand theft charge as part of that. So those were 5-year maximums per count. Then you've got the misdemeanor 24 MM 4346, which were 2 misdemeanors, possession of drug paraphernalia and resisting without violence, which are also punished by up to a year in county jail. Do you understand that?
Yes, sir.
Okay. Is this the plea you want to enter today?
Yes, sir.
Did you go over this plea with Mr. Russell?
Yes, sir, I did.
And did he answer all of your questions?
Yes, sir.
And you understood it?
Yes, sir.
Did you sign it?
Yes, sir.
Okay. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Any mental health issues or concerns
No,
for
sir.
you? Anyone threaten, force, or pressure you in any way to do this?
No, sir.
Anyone promise you anything in return for this plea?
No, sir.
Do you understand that in the violation of probation in 24 CF 1192, by entering an admission to your violation, you're giving up your right to an evidentiary hearing?
Yes, sir.
So the state won't have to prove anything as far as you violating your probation?
Yes, sir.
You're okay with that? Also, in the misdemeanor case, 24 MM 4346, you're giving up your right to a trial by entering a plea of, looks like no contest.
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand the state won't have to put any witnesses or prove that case at all?
Yes, sir.
You understand you're waiving all the defenses that you may have had to those charges?
Yes, sir.
All right. And what is your date of birth and how far did you go in school?
1189, and I have a high school diploma. 11869, sorry.
I don't think I heard all the numbers in the book.
11869.
11869.
And I got a high school
You
diploma.
said 1189. I'm just waiting for another number there. All right. Okay, and what is your plea on the violation of probation? Are you admitting or denying?
Admit.
Okay, and as far as the misdemeanor case, what is your plea?
No contest.
All right, I'm going to accept your admission in 24 CF 1192 and accept your no contest plea in 24 MM 4346. It's going to be adjudication, all cases, all counts. In the felony case, revoke and terminate your probation, 270 days county jail, concurrent with the misdemeanor case, credit for any time served, $150 PD fee, $100 cost of prosecution. Those monies owed will be sent to judgment. 24 MM 4346, adjudication of guilt, time served, court costs. Do we know what the court costs will be?
You know what the court costs would be on a paraphernalia?
270. Okay. $270 in court costs, $100 PD fee, and then those monies owed will be sent to judgment as well. All right. Ms. Flores, I'll need you to be fingerprinted, and then you've got 30 days to appeal the judgment and sentence of this court.
Okay.
Thank you, Ms. Flores.
Thank you.
Judge, can I call somebody out of custody?
Sure.
Gatewood? Gatewood is present and approaching. Judge, this is case number 23 CF 1533. Defense had filed a motion to modify the conditions of her release. According to the original first appearance paperwork and some of the pretrial supervision paperwork, her contact with the children in this case, there's an alleged child victim, and there's also some child witnesses, was restricted, it looks like, to no contact. The state and I have talked. We've agreed to, the kids are currently with their father, agreed to supervise contact.
Out of state, is that what I read?
Out of state.
Pennsylvania, I think.
Something like that, yes, sir. Supervised contact or visitation with the kids, and the visitation will be supervised by the father because DCF is not involved in this case.
Okay. And father was okay with that? I'm assuming someone talked to him?
Yes, Judge, we've talked to him. He was
Sorry.
fine with contact outright, but the state is not.
All right. Coming from the dependency and family law divisions, that comes up a lot, so I just want to make sure it was asked. All right, so what you're asking for at this point is to just modify the terms of her bond to allow supervised contact with the child alleged victim as well as the children who are witnesses, who are her children, correct?
Correct, Judge.
All right, supervised by the father.
Their father.
And what is his name? Is it listed?
Ryan
Honestly,
Gatewood.
It's Ryan Gatewood? Okay. I just didn't know if y'all were married, if paternity had been established. I don't want to say father, and then there's a disagreement as to who that is or something like that. It's just, I like to make sure everything's tightened up as much as I can get it. All right. And there's no DCF case involved?
No, they closed their case.
Okay. All right. So there was never a judicial case. It would have been mine, though. Probably would have remembered it. So, all right.
Okay.
Anything else?
And then put this on the pretrial conference 224, Judge.
All right, February 24th will be your next court date. That'll be in the afternoon at 1:30. Anything else? All right. Thank you, Ms. Gatewood.
Yeah.
That's mine. Morning, Judge. This is Catherine Elizabeth Lockart before the court in 2018, CF 751, and 2019, CF 2433. She is prepared to enter an admission today. We have an agreement with the state. We have previously gone over the agreement. She's going to do the 9 months. Okay. And we've gone over all the terms. She just needs to sign at the top. I may approach.
All right, Ms. Lockart, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right, your name and date of birth?
Catherine Elizabeth Lockart, 11/23/92.
All right, Ms. Lockart, you're here in 18 CF 751 and 19 CF 2433. I've been handed a violation of probation plea agreement. Did you go over this with your lawyer?
Yes, sir.
Did you understand it? Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did Ms. Flowers answer any questions you may have had about it?
Yes, sir.
Are you satisfied with her advice and representation?
Yes, sir.
Do you need more time to speak with her about it?
No, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Any mental health issues or concerns?
No, sir.
Anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
And anyone promise you anything in return for your plea?
Sir.
All right, do you understand? It's going to call for 9 months jail with credit for time served, revoke and terminate your probation. Is that what you
Yes,
want to
sir.
do? All right. Do you understand that if you admit to your violation of probation, there won't be a hearing of any kind where the state would have to prove that you violated your probation?
Yes, sir.
Okay, and you're waiving any potential defenses that you may have had?
Sir.
Okay. And what is your plea? Are you admitting or violating, or admitting or denying your violation of probation?
I'm admitting violation of probation.
Okay. I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty. 9 months county jail, credit for time served, $100 VOP fee, $150 cost of defense. Those monies will be sent to collection, revoke and terminate your probation. You'll step over, be fingerprinted. You have 30 days to appeal the judgment and sentence of this court.
Sure.
All right, thank you. Concur. Is this a guideline sentence? Oh, never mind, it's right here.
Yes, sir.
Yes, okay. And this is Summer Lyons. She's before the court in 21 CF 1236. We have an agreement with the state. Let me just inform her of what we decided on. If I could approach with the agreement is question. Thank you.
Yes, Judge, and just to clarify, Ms. Flores and I had talked about the credit stipulation, and just to make things simple, the state would just stipulate the credit for time served for Ms. Lyons.
Okay.
Initially, it was intended to be 1129, and it's understood she's served that time. We would stipulate to her getting that credit from out of jurisdiction, so.
Okay, so but for purposes of the plea, we're just calling it time served?
Yes, sir.
Okay.
Yes, and I didn't want to make it super messy. Should I just cross all this out and put credit for time served so that it's?
I think if that's what y'all are agreeing to, that's what it should say.
Okay. I am going to.
Otherwise, there could be confusion later, and then she doesn't
Yeah.
get released. And
Okay, I apologize, I don't have a
Oh,
whiteout, so I'm
that's
just
fine.
going to,
just make sure that she initials next to it.
I'll leave the $50 VOP fee and the $150 cost of defense, and we'll send those to collections? Okay. Do you want 90 days to pay them?
Yes, that's fine.
Okay.
Sorry.
No, it's okay.
And then my DOC time is done.
Well, you're not getting any more DOC time for this case. Admit credit for time served. Okay.
Ms. Lyons, can you raise your right hand? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your name and date of birth, please?
It's January 25th, 1985.
Okay. And Ms. Lyons, did you go over this plea agreement in 21 CF 1236? Did you understand it? Did you discuss it with Ms. Flowers, your attorney? Did she answer any questions that you may have had? Okay. And do you understand that it calls for basically time served? I know there's a bunch of stuff written on here, them trying to figure out your credit, but they've just, at this point, agreed to time served, so you'll be released as far as this case is concerned. All right.
Done with DOC, I didn't get any answers.
I'm, whatever DOC, whatever, will be separate. Yeah, whatever they told you at
Does she
DOC.
have a different DOC sentence?
She just completed a 4-year DOC sentence, and that was the issue. We wanted to give her the credit. She's been on a detainer since 2023 on this case. So the intent was not to have her serve any more time and to keep her from having to go back to DOC. But I'm not sure about the registration requirement. If it's required for your other case, okay. It's not required for this case.
Okay. Well, just make sure you do what you think you might be required. It's always better to ask and try to do it than just wait for them to come talk to you about it. Because usually when they do that, it's with a warrant. So, all right. So did you understand all this? All right. And are you under the influence of any alcohol, drugs, or controlled substances? Any mental health issues or concerns? Anyone force, pressure, or threaten you to do this? Did I say that already? I think I've done so many already this morning, I can't remember where I'm at in my colloquy. Did anyone promise you anything in return for this plea? Okay. Where was the DOC sentence from? Escambia County, okay. All right. You understand by entering an admission to your violation of probation, there won't be a further hearing where the state would have to prove that you violated your probation? Okay. And what is your plea, admit or deny? All right. Accept your admission to your violation of probation in 21 CF 1236. That's freely, voluntarily, knowingly given. I'm going to adjudicate you guilty of both counts. Time served, $100 VOP fee, $150 cost of defense. I'm going to give you 90 days to get those paid, or certainly set up a payment plan with the clerk's office. Anything else that I may have missed? This is the state's agreement and a guideline sentence.
Yes, sir.
Step over, be fingerprinted, ma'am. You have 30 days to appeal the judgment and sentence. The score sheet says the judge is Michael Flowers.
I have
Let's cross that off, just so there's not any
those.
confusion.
What?
The score sheet says Michael Flowers.
Oh.
I think sometimes it's the original
It's
sentencing
the
judge.
way that our,
I understand. I'm just going to change it. Otherwise, people are going to think that's weird that
Thank you, Judge.
there
This is
wasn't a conflict there.
Right. Thank you. This is Justin Cox before the court in 23 CF 1502 is a VOP, and 24 CF 2563 is the new law violation. We've reached an agreement on both. We've gone over the agreement and the terms, Mr. Cox and I, and he just needs to do his signature here at the top. You're good. Okay. If I may approach.
oh. Judge, we had to modify the score sheet. Showing this to Ms. Flowers.
And that's correct.
Because we only have this, the issue with this is 6.
So he scores 25.8 months, and there's a 50-month suspended sentence. I just want to make sure I'm right
Correct,
about it.
Judge.
Sorry. If I came off as questioning, I just want to make sure I'm right, not that I'm saying you shouldn't be doing this.
That is the agreement.
Okay. It seemed like one of the charges was missing. I think I found it. All right, no problems. All right, Mr. Cox, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your name and date of birth?
Justin James Cox, June 27, 1988.
And did you go over this plea and sentencing agreement for the VOP in 23 CF 1502 and the new case of 24 CF 2563?
Yes, sir.
All right, calls for you to get 18 months community control with a 50-month DOC suspended sentence?
Yes, sir.
All right, do you understand that means that you can get 50 months if you were to violate your probation?
Yes, sir. It ain't happened.
Okay. All right, and you'll have to complete all the original terms of your probation, substance abuse evaluation, recommended treatment, and some costs. Is that what you want to do today? Okay, are you sure?
Yes, sir.
I just, you kind of wavered when I asked you that.
Oh, no, I was catching all of it in.
That's fine. If I talk too fast, or you don't hear me, just make sure you ask me to repeat it. All right, so this is the VOP, and then it's going to be just count 2, the paraphernalia in the new charge. It's going to be a null process on count 1. Is that right, State?
That's correct.
Okay, thank you, Ms. Turner. All right, did you go over this form with Ms. Flowers, your attorney?
Yes, sir.
And did you understand it? Did you sign it?
Yes, sir, I gave him a scribblester.
All right. Did you have enough time to speak with her about it?
Yes, sir.
Did she answer all your questions?
Yes, sir.
Are you satisfied with her advice and representation?
Very.
Okay. Are you under the influence of any alcohol, drugs, controlled substances? Any mental health issues or concerns? Anyone force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for the plea? You understand if you admit your violation today in 23 CF 1502, there won't be a further hearing where the state would have to prove how you've violated your probation?
Yes, sir.
Okay, and you understand that in the new case, 24 CF 2563, that there won't be a trial of any kind, and you've waived your trial rights by entering a plea?
Oh, yes, sir, yes, sir.
Okay, and you've gone over those trial rights that were in this form? Do you understand those as well? Okay. And as far as the VOP, what is your plea? Are you admitting or denying your violation of probation? Are you saying you did it, or are you
Yes,
saying you
sir.
didn't
Yeah.
do it?
Yes.
Okay, so you're admitting? Okay. And as far as the paraphernalia charge, are you pleading guilty, no contest, or not guilty? I think it's listed here as nolo contendere.
Oh, no contest, yeah.
Okay. All right, I'm going to accept your admission to the violation of probation and your no contest plea to the possession of drug paraphernalia in 23 CF 1502. It's adjudication of guilt, modify and reinstate supervision to 18 months community control. Does he have more than 18 months left?
Yes, Your Honor.
Okay, so after the 18 months is up, you'll finish out your term of regular probation.
Yes, sir.
Do you understand that?
Yes, sir.
Okay. Complete all of your original terms, substance abuse evaluation and recommended treatment, $100 VOP fee, $150 cost of defense, waive cost of supervision, and again, that's the 50 months DOC suspended sentence. The second case, 24 CF 2563 on count 2, adjudication of guilt, credit for time served, $270 in court costs, $150 well, that's a misdemeanor. Should only be 100.
We'll change it to 100, yeah.
Saved you $50. $100 cost of defense to be paid during the course of your supervision. That's in the felony case. Anything that I've missed?
It's a downward departure, Judge.
It is a downward departure based on a plea bargain. Is that right?
That's correct.
Okay. Anything else, Ms. Flowers? For Mr. Cox?
That's it.
Okay. All right.
Did we waive costs, continue waiving
I
cost
did
of
say that,
supervision?
yes.
Thank you.
Step over, be fingerprinted, 30 days to appeal the judgment and sentence of the court.
Mr. Cox? Oh, yes. Yes, I was looking for his plea that we signed. He was supposed to be on, well, we got confused. He wasn't on the docket. Can we just recall him so I can find it in my bag? It was signed last week. We're resolving it today. Just let me get the paperwork. Okay.
Call you back up, Mr. Salzman.
Who was, I'm sorry, who did we just send?
That was Sawzak. She just has to get the plea form that's already been signed. So we'll recall him.
Okay.
Okay. But this is Justice Christopher Stearns. He's before the court today in 24 CF 1853 and 24 CF 2625. Those are both violations of probation. We have reached an agreement with the state, and I've gone over the agreement with Mr. Stearns. He just needs to physically sign the agreement. Okay. Let me approach.
Thank you. All right, Mr. Stearns, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. I've been handed a violation of probation plea agreement in 24 CF 1853 and 24 CF 2625. Did you go over this agreement with Ms. Flowers, your attorney? Is this what you want to do today? Did you understand the agreement? Did you sign it? Did you have enough time to speak with her about it? Are you satisfied with her advice? All right. And any alcohol, drugs, or prescription medications?
sir.
No. Any mental health issues or concerns? Anyone force, pressure, or threaten you to admit your violation of probation?
No, sir.
Anyone promise you anything in return for that?
No.
Say? Okay, I just didn't hear you. There was a jingle of the chain. I couldn't quite hear you. All right. All right, do you understand by entering an admission to your violation of probation, there won't be an evidentiary hearing where the state would have to prove how you violated your probation? And you're waiving any potential defenses that you've had to these violations. All right. And what is your plea? Are you admitting or denying your violation?
Admitting.
Okay. I'm going to accept your admission to the VOP in both cases. It's freely, voluntarily, knowingly given. I'm going to adjudicate you guilty on all counts, revoke and terminate your probation, sentence you to 9 months in county jail with credit for time served. Is that what your agreement was?
Credit for all time served, yes.
All right,
On
$100
these
VOP fee, $150 cost of defense, and all those monies will go to collections. Anything else from Mr. Stearns? This is a guideline sentence.
I have just 2 VOP fees, I believe, one for each case.
Thank you. I think you just need to get.
Sykes?
This is Stephen Dwayne Sykes before the court in 23 CF 79. It's a VOP. We have reached an agreement with the state. Mr. Sykes and I have been over the agreement. Again, he just needs to physically sign the agreement. Give me a print.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your name and date of birth, please?
Stephen Sykes, 8/7/1982.
All right, Mr. Sykes, I've been handed a plea agreement for your violation of probation in 23 CF 79. Have you gone over this agreement with Ms. Flowers, your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
Calls for 12.1 months DOC. Is that your understanding?
Yes, Your Honor.
Okay. Are you satisfied with Ms. Flowers' advice and representation?
Yes.
And are you under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Any mental health issues or concerns for you?
No, Your Honor.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Anyone promised you anything in return for your plea?
No.
Do you understand that by admitting your violation of probation, you're giving up your right to an evidentiary hearing where the state would have to prove that you violated your probation in the ways they've alleged?
Yes, Your Honor.
And you're waiving any potential defenses that you've got under those? All right. And are you admitting or denying your violation of probation?
Yes. Admitting.
Admitting?
Yes.
You're saying you did it?
Yes, Your Honor.
Okay. All right, I'm going to accept your admission to the violation of probation in 23 CF 79 is freely, voluntarily, knowingly given. Adjudicate you guilty, 12.1 months DOC with credit for all time served. Revoke and terminate your probation. Restitution to a civil lien, $100 VOP fee, $150 cost of defense. Those will go to collections as well. All right, step over, be fingerprinted. You have 30 days to appeal the judgment and sentence. This is a guideline sentence as well. I'm served on the misdemeanor.
Yes.
I can't give him 12.1. So.
I'm not.
All right, thank you, Mr. Sykes. Mr. Cox.
He's going to need a... Judges, this is Herbert Atkins. Case number for the record is Hold on. Judges, this is Herbert Atkins. Case number is 2007 CF 622. It's here for a status on his VOP. On Mr. Atkins' case, the state and I have talked about possible resolutions of his case, but we're going to have to look into it more because of his status. So at this time, we're just going to ask for continuance without subpoenas down the line. In the meantime, we're going to see if we can find a place for him. And then if there's no options, then we can talk about whether we're going to set it for hearing or not.
Okay, so do you want the March date?
Yes, sir. What's going to be your...
March 27th is our next miscellaneous.
And that would be at 9 o'clock, Judge?
Yes.
Okay. Did you hear that, Mr. Atkins?
I hear you, but I didn't hear him.
Okay. The judge set your next court date for March 27th at 9 o'clock. Here's a copy of all that paperwork that you wanted, okay? Since I couldn't see you at the jail, there's a copy. I'm going to come back and see you before then. But right now, you're set for March 27th, okay? Okay.
Obviously, if y'all work something out, you can try to get it in sooner if
Yes, sir.
there's a place for it.
Judge, this is James Banks. Case numbers for the record are 23 CF 1081, 23 CF 1083, and 23 CF 1554. And we may have an agreement worked out if I could have a moment.
Steve, how many?
Judge, I have a plea agreement and a score sheet if I may approach.
All right, so it calls for 60 months DOC, score 62, so it's a slight downward departure?
Yes, Your Honor.
Okay.
Yes.
Banks, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I swear.
Okay. Can you state your full name and date of birth, please?
James Henry Banks, Jr., 9/28/2000.
Mr. Banks, you can put your hand down. All right, I've been handed a plea and sentencing agreement in your 3 felony cases that calls for you to do 60 months in the Department of Corrections. Is that your understanding?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Okay. Did you go over this form with Mr. Russell, your attorney?
Yes, sir.
Did he answer all of your questions if you had any?
Yes, sir.
Did you understand the document?
Yes, sir.
Including your trial rights?
Yes, sir.
And did you sign the agreement?
Yes, sir.
All right, are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Any mental health issues or concerns?
No, sir.
Did anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Okay, and it's as charged except for count 1 is reduced from armed burglary of a conveyance to just burglary of a conveyance?
That's correct, Judge.
Okay, so Mr. Banks, you understand that makes it go from a first-degree felony potential life sentence to a third-degree felony with a 5-year maximum.
It's still 60 months, though.
Yes,
Correct.
but I just want to make sure you understand that, there's a serious reduction of one of your charges.
Yeah, I'm grateful.
Okay. I wasn't asking if you're. I'm not the one that's doing, that's the state's agreement, so. All right. Do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
And you understand those trial rights I talked to you about?
Yes, sir.
And you're giving those up?
Yes, sir.
And you're waiving any potential defenses that you have in all 3 of these cases?
Yes, sir.
And what is your plea to all 3 cases?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given in 23 CF 1081. As I stated, count 1 is a lesser included offense of burglary of a conveyance, F3 L4. As far as the felony counts, it's going to be adjudication of guilt, 60 months Department of Corrections, concurrent to each other and to any other sentence that you're currently serving. Court costs in each case. Can we get a number on that, potentially, Arlene? $150 PD fee in 23 CF 1081, $100 PD fee in each of the other 2 cases. Money owed will go to judgment. Order restitution and reserve for a period of 90 days for that to be determined. And then count 6 of 23 CF 1083 is a misdemeanor, so that will be time served. Also order restitution and reserve on that amount for a period of 90 days. Did I miss anything?
No, you don't.
State's agreement?
It is.
All right, and it's a slight downward departure like I talked about.
Yes, Your Honor. Just a clarification on the restitution. I don't know if I missed. It's to go to collection.
I think it'd have to be a lien once it's determined.
We said it.
Right, after we said, yeah.
We'll address it at that point, but it'll be a civil lien once it's assessed at a certain amount, if there
Yes,
is anything.
Does Madam Clerk need to announce the court cost per case, Judge?
Yes. 515 for each of the cases. And again, that will be sent to collection.
That's it. That's all.
Anything else for Mr. Banks?
Pay for.
No, you don't.
All right. Mr. Banks, step over and be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
Judge, this is Lori Beckham. Lori Beckham, case number is 24 CF 2185. This case is set for a competency hearing today. I have a copy of Dr. McDonald's report. I've already provided a copy to the state. We used to file these things, but the clerk would not treat them as confidential, so we've stopped doing that. So I'm going to file a copy of the report today and ask that the court order that it be sealed. But she was found incompetent to proceed, if I may approach.
It was opined by the doctor that she was.
Yes, sir.
And the state's not quite ready to stipulate to the report, Judge. I had some questions that I want to address with Dr. McDonald, maybe outside of the court setting. Particularly.
There's only one report?
Yes, sir.
Correct, right. We've only done just the one eval with Dr. McDonald, Judge.
Yeah, this was an arrest in September of last year.
So what are you asking for?
So I noticed I guess you could call it the recommendation from Dr. McDonald would be that she be court ordered to Appalachia Center, which I believe Dr. McDonald describes as a secure residential facility.
Okay.
So at the same time, Dr. McDonald says that Ms. Beckham does not qualify for involuntary commitment. And I wanted to make sure that those two things don't run afoul of each other.
And Judge, there have been some recent changes with competency training and stuff that I had spoken to Dr. McDonald about. I think she's the one that told me that if there's anything except involuntary commitment, then Ms. Valencier with conditional release would have to be involved in blah, blah, blah. And I've tried to reach Ms. Valencier to confirm all that, and if I do, then she might need to be here to give input and stuff. So what the state and I were looking to do is postpone it to another date she's going to talk to Dr. McDonald, and I'm going to try to get a hold of Ms. Valencia, and then maybe by the next court date, we can figure out, what we need to do.
I just want to make sure that, Your Honor, if you're going to be court ordering her to a secure residential facility.
Well, I think he's asking to postpone it, so.
Yeah, no objection. I just wanted to make sure the issues are.
Well, I
clear.
think you're just trying to clear that particular part up, because I'm reading that too. As far as the findings and recommendations, it says, as she does not appear to meet statutory criteria for involuntary commitment, most appropriate placement, secure residential treatment facility.
Yes, sir.
Is the state objecting to a finding of incompetency at this point? We just don't know what to do.
At this point, yes, I just want to make sure we don't put the cart before the horse. I don't know that I can stipulate to that report the way it's written. I have some questions, so without that, I don't think.
At the end of the day, the only thing you'll have stipulating to is the use of the report, and then I make the decision on it. So if you're not stipulating to the ultimate findings, then maybe Dr. McDonald can give us an amended report.
Okay, I can check into that, Judge.
Just so it's clear as to what she's recommending.
I would prefer that, Judge.
So I'm going to give you this one back.
Okay.
That way, if she does an amended one, otherwise bring this next time, but I reviewed it.
Yes, sir.
What I don't understand is the issue with the confidentiality of these reports. So I'm not sure what
We've gone round and round with the clerk's office, Judge, and that's their position, and so.
If I may, could you not file a motion for the court to determine confidentiality, and then the court could
Well,
order that it be sealed?
I think part of the issue that it comes up as is you guys in Okaloosa County, it seems, file them when you do them yourselves ahead of time without getting an order to do it. You file it as reciprocal discovery.
We do, but there's also a form that, a notice of confidential filing or something like that, that's a form that we used to file with the clerk's office, and then they would seal it, and the general public couldn't get access.
I think the issue is when it comes in as a response to discovery, as a reciprocal discovery, it's probably not being marked as confidential.
We filed both of them at the same time.
Well, that's the issue. I've got a response. I don't see a notice, but then again, you didn't file it this time. But in the past, I haven't been able to find them unless I look for those response to discovery. So I think it's just, if you file the response to demand for reciprocal discovery that lists the evaluation report, and then you file the report separately as a notice of confidential filing, I think that should do it. But I'm certainly be happy to be part of the conversation as to how we can figure this out.
Okay. I can talk to the head assistant at the office, but she's, like I said, she's gone round and round with the clerk's office, and we can't. They won't. But she knows more about the logistics than I do.
Okay, well, whatever I can do to be of assistance to the parties, I'll certainly do that. All right, so when do you want to place this on the next docket?
Is 327 your next?
That's my next miscellaneous, but I don't think it's going to take us that long to get to this figured out, right?
That, like I said, I'm just going to talk to Ms. Valencia and then talk to Dr. McDonald, so no, sir. Do you have a date?
Why don't we put it just on the 2/26 pretrial? And she's in jail. We'll put it that date.
Okay.
I think that's the soonest I've got. I guess I will tell you all about this because I think we've talked about it somewhat before. During my trial weeks, which includes next week, I don't have a trial now in civil. So if we need to add anything that can get people moving along or anything like that, I'll certainly consider placing something next week, especially on our Thursday pretrial detention docket. So if we want to just kind of use that afternoon as well for anything that you guys can agree to put cases there for purposes of pleas or bond hearings or things that are kind of time sensitive, we can certainly do that. So
just contact
my assistant to make sure. Sometimes when I don't hear anything, I may schedule other things, but I'll typically leave those Thursday afternoons of my trial weeks open if I don't have anything else, so we can use that for more time.
Thank you, Judge.
Yeah.
Thank you, Judge. Okay, we'll see you. Judge, this is Nolan Chesher. Case number is 22 CF 1321 and 23 CF 54. What I'm going to have to do is pass Mr. Chesher's case for a second to let him read the potential plea agreement in the case. Let me have a second. So, Judge, at this time, I'm just going to send the agreement back with Mr. Chesher so he can read it over and then bring him back in a little bit. Judge, this is Zachary Dalton. Case number is 2007 CF 2678. This is here on a violation of probation. At this time, we'd ask to set it for a hearing.
An evidentiary hearing?
Yeah.
Yes.
I don't really have anything until that March 27th date, unless you guys want to try to, I don't think you can get subpoenas out for next week.
No, March 27th would probably be better.
All right, March 27th, I'm going to put that in the afternoon.
That will be fine, Your Honor.
All right, 2 o'clock. We'll see you back on that date for your evidentiary hearing.
Sir. Thank you.
Daniels?
Come on, right here. Judges, this is Rico Daniels. Case number is 24 CF 2584. I think we've reached an agreement in this case, but I would like to send it back with Mr. Daniels so he'll have plenty of time to read it over.
Plea agreement?
Huh?
A plea agreement, you mean?
Yes, sir.
'Cause we're here for a bond hearing, right?
Well,
I just want to make sure I've got what you're saying, that you're not agreeing on a bond amount. You're agreeing on a plea.
we were set for a bond hearing, but the state made an offer and I've conveyed it to Mr. Daniels. And so we would like to withdraw our bond hearing, and then if he's okay with the plea agreement, he'll go ahead and do it. And if he decides in the back that he doesn't want to do that, then we'll go forward with the bond.
hearing.
Yes, sir.
Thank you. All right, Mr. Daniels, we'll call you back up once you've had a chance to go over the plea agreement.
Here, just take that with you and read it, okay?
Ellis.
Judge, this is Clarence Ellis. Case number for the record is 2018 CF 2645. To refresh the court's recollection, Mr. Ellis was found incompetent to proceed back in April of 21 and placed on conditional release. Dr. McDonald did the evaluation back in January of 21. We had passed it to today because we were going to get an updated evaluation. We have sent all the paperwork over to Dr. McDonald's office. We don't have a report back yet. So we're going to ask that you pass the case so that we can get that report.
No objection.
All right. Let's put it to March 27th, but again, if you get something earlier and you can bring it in, we'll certainly consider that. 9 o'clock.
Supposed to sit up here for that long?
Judge, this is Travis Feaser. Case number is 23 CF 2124. If I could just have a moment. On Mr. Feaser's case, Judge, we're going to ask to set it for a evidentiary hearing.
All right, March 27th, 2 o'clock for an evidentiary hearing. March 27th.
Good morning, Judge. Judge, I spoke with the client this morning. He was brought over from the...
And who was this?
Mr. Gormley, Andrew Gormley.
Okay.
It was one of Mr. Gibbs' cases.
Got it.
He was brought over from, I guess, the state prison. Is that where you are? Yeah, brought over from the state prison either late yesterday. He was not on their jail roster yesterday, but I did speak with him this morning. It seems that all of this is about credit for time served. Otherwise, an agreement has been reached. I did locate the plea offer in the case. It is on our server, and I've sent it to the printer. What I'm just going to ask for now is, can we bring him back this afternoon? Hopefully, I'll be able to get it resolved by then. What we may wind up having to do is punt it to the court on the issue of the credit for time served after the detainer. He's got similar cases in other counties that he's been sentenced on. In those counties, at least one of them I was able to find where he was given that credit. And in talking with him today, he's in agreement with the overall plea offer. The question is the credit. Reviewing an email chain that was sent to us by the state, it looks like the prosecutor that's assigned to the case over in Escambia does not want to agree to that credit, wants to just punt it to the jail or the Department of Corrections to determine the credit. And he, of course, wants the court to announce the credit.
All right. If y'all aren't coming to agreements on credit, then you got to get me something in advance that explains what your concerns are and what it should be. Because I understand credit's a concern, but also if these are all running concurrent,
Yes, sir.
I've never once in 17 years as a defense lawyer asked a judge to determine credit.
Judge, it may, and I'm okay now. When is our next date? Maybe
we can do it. Get me something for this afternoon.
Yes, sir.
I think your client would like to say something to you, Mr. Williams.
Yeah, just to clarify, I'm covering for ASA Atkins here on this case. The only, disagreement, we don't have to agree to a credit, but we do agree that he should be entitled to all the legal credit that he has.
Your Honor, may I say something?
If you'd like.
I brought the court minutes from Santa Rosa County with me, okay? And I had Bo Powell as my attorney over there.
Okay.
Ms. Hutchins, at the time, tried to contest the clerk's, the clerk's, I guess, take on what the time I was due. I was arrested in Santa Rosa County 2 months after I was arrested in Okaloosa County. I was moved from Escambia to Okaloosa in May to have my warrant served. I was moved from Escambia to Santa Rosa in July to have my warrant served. So 2 months, almost 2 months to the day. Ms. Hutchins came back and said that she wasn't going to give me, she said, I'm not doing that. And Mr. Powell said, well, you have to. And her answer verbatim was whatever. And she kind of turned her head and walked away. But the clerk told me I was eligible for that time. And even here in Okaloosa County, when I was here last time and we didn't resolve it, when I was in a holding cell in the main lobby of the jail, a clerk from, someone in a clerk's uniform came by, and I asked them if I could ask them a question. And I showed them the court minutes.
All right, Mr. Gormley, I'm not going to listen to what your hearsay comment about what some clerk in another county said about it.
Well, no, this is your county, sir. This was your county. This was here in Okaloosa County.
You talked to one of our clerks where?
There was a person walking through from the administrative part to the main office wearing a clerk's uniform here.
At the jail?
At the jail, yes, sir. And I said, may I ask you a question?
Clerk's uniform.
Like a clerk's, they had like a clerk's shirt.
Like the polo shirt, I guess,
Yeah, polo
Judge.
shirt, you know, and it said office, the clerk's office.
Why are there clerks at the jail?
Oh, they were there though, sir.
All right, well, again, unless you're going to ask that person to come up and raise their right hand and tell me what they told me, I'm not, listen, you've got cases in 3 different counties in our circuit. I can look at the things, but I'm not going to do it on the fly without some sort of roadmap as to what you're asking for. You know, Mr. Williams, what you gave me for the other case earlier this morning, that explained everything I need to see, but now we're talking about different counties.
Yes, sir. What I can hand you the court minutes from that case.
I can pull every court record from across the state if I want to,
And
Mr. Gormley. I can see it. Again, I don't want to do it while I tell people all this time, y'all aren't here to watch me read. If you give it to me in advance, I'll read it. I tell that every single time. There was a day in the past week I got something after 10 o'clock and I stayed up until almost midnight reading and researching it because of new issues. I do it. I don't just say I do it, I do it. So if it's given to me in advance, which means if you can give it to me now, and we can talk about it this afternoon.
Do you mind if I go ahead and give him?
Absolutely not, sir.
From what dates? Again, I'll look them up. I don't need your actual paperwork, but what dates are they from?
Judge, this is going to be dated August 22nd, 2024. Both of them are August 22nd, 2024. One is, looks like 24,973. The other one's 23.
Okay. I'll take a look at it. We can call back this afternoon. But again, if this stuff is given to me in advance, I'll look at it. I don't want to put you on another date, Mr. Gormley. I want to get this figured out for you just like you want it figured out. But, you know, the situation is you're getting moved back and forth because this wasn't all done as one big plea offer. And it sounds like there's a disagreement potentially with a different state attorney from a different county. I'll take a look at it. But it's hard to do these things on the fly, and we spend 15 minutes doing it where everyone's sitting here as opposed to me looking at it for 15 minutes in my office over the lunch break or whatever we've got. So we'll call you back this afternoon.
All right, Judge, thanks.
Sir, Matt, what are my options if I've been constantly contacting?
Your options are to enter a plea today or not. What do you mean? What are your options?
Because I've been constantly reaching out to the public defender's office. My family has. I've written at least 5 certified mail letters to them, and I've gotten no response. I want to resolve. So I'm committed to putting this behind me and making things right with anybody I need to make things right with. All I'm trying to do is resolve this so I can, because it's affecting my custody level in DOC as well, which will prevent me from going to work release sooner. That's my only concern, but I have been on this nonstop.
So what are you asking for?
I'm just asking I agree to the terms of the global plea.
Okay, so
they're concurrent. I just want to make sure that the date that I've been sentenced to get out of prison in Escambia and in Santa Rosa, since it's a global plea and everything is concurrent in all the other counties, that the day I get out here is the same day, that I'm not getting an additional 6 months tacked on to my sentence.
Ms. Leone, are you considering this a global plea?
No, Your Honor. This is a separate plea.
It's the same terms, Judge. I've reviewed the plea agreements that were in the other counties, and then I found on Tim's Drive the plea agreement that he had. I've looked at that. It seems it's written by the same prosecutor. It's the same language. It's the same terms. I think that's what he's talking about when he says global offer. There's a separate one for each county because it's each county.
I understand, but they all have to be accepted by the individual judges who are handling
Correct.
these
Yes, sir.
cases.
Yeah, I was told it was a global plea when it was
It's
presented
a global
to me.
plea offer.
From Ms. Hutchins, it was a global plea, and I, even in front of Judge Kinsey, she stopped and went in because she gave me her word, and I said, I don't mean anything disrespectfully, but I want this in writing. So she went back, amended the original paperwork.
Who did?
It would be Judge.
All right.
Hutchins.
Can one of you speak at a time, please?
Angelique Hutchins, sir.
Okay.
And she went back and amended it and said that everything would run concurrent with Santa Rosa, and it would run concurrent with Okaloosa.
Okay, let me explain something to you, Mr. Gormley.
Yes, sir.
That may be a global plea offer.
Yes, sir.
But each plea needs to be handled in each county, and each judge who's assigned in each county to your cases has to accept them. So a prosecutor in Escambia County can't tell me that I have to accept a plea. Neither can a judge in Escambia County, just like I can't tell them what to do.
So this isn't getting passed to me by my attorneys, I guess is what the problem is. So I'm clueless, and I apologize for speaking so much, but it's my life.
You're going to have all the chance you want to speak. All I'm saying is I'd like to look it over because you want me to do something that's usually not asked to do. I'm asking for time to do that.
Yes, sir.
This afternoon.
Thank you. I apologize. I'm just.
Well, I'm just trying to make sure you understand
Sir.
that global plea offers are offers, but they have to be accepted by each individual court. I'm not saying I'm going to reject it in any way, but I haven't even heard what the plea offer is. What is the plea offer?
Judge, I'll have to bring it up on my computer. It was not in the file.
Mr. Gormley, what do you think your plea offer is?
I believe it's 54 months state prison, Judge.
I have it right here.
Okay. And I've got it up on my system, too.
That's it right there.
It is 54 months in state prison concurrent to other cases and counts in Escambia County having case numbers. I won't recite the case numbers here. Cases and counts in Santa Rosa County having case numbers, and all counts in Okaloosa County case numbers. 218 mandatory court costs, restitution, the amount of $6,585 payable to Beverly Steel, reduced as a lien. And then everything else, the other counts are running concurrent. And then on the other case, again, adjudication of guilt, 54 months in state prison, concurrent to other cases, and then recitation of the cases.
Okay, and that's the state's offer?
It is.
Okay. So again, I'll take a look at it, but if you want me to determine credit, you got to give me some time to actually look at it. And now we've spent 15 minutes talking about it, and we haven't even got anywhere.
I apologize.
No,
sir.
it's
I'm
just there just needs to be a
frustrated.
better way of getting these things to me in advance so I can read them.
I didn't.
And I'm not. This is nothing against you, Mr. Gormley. And if I'm said anything that makes you think I'm not going to accept the plea, that's not. But I still have to actually go through the process of doing it. So, but I like to be thorough. I don't like people having to come back to figure out some jail credit where you're off to DOC, then there's a problem, and you're sent back again. You know, there's a bill in front of the legislature right now to try to handle some of these things when you're at DOC differently if there's pending cases. You know, the process is the process, but we have to go through it as arduous as it may be at some point. But I just like to take a look at it today, and then we'll come back this afternoon and make a decision on it. Okay.
Thank you, Judge.
Thank you.
Good. All right, we'll see you in a little bit.
Judge, this is Shelby Green. Case number is 24 CF 1790. Ms. Green was set for today for a status. We thought we might be able to work something out, but we haven't been able to. So we're going to ask just put it on the 2/26 pretrial conference date.
2/26 at 9 o'clock for your pretrial conference, Ms. Green. Okay.
I'll be out to see you.
Thank you.
And then, Judge, I'm going to go back in the back and talk to some clients, and I'll come back and finish up mine.
Okay. Ms. Rivers?
I don't have anything
You don't have anything
further,
else?
Your
You're just
Honor.
hanging out? Ms. Flowers?
Judge, I'm sorry, go ahead.
If I could just briefly recall the Sawzak
I was unable to find our previously signed agreement, but I've drafted a new one.
Okay.
Same terms, just going to have him quickly sign it. Yes.
Thank you.
I didn't, but I wrote a new one the exact same way. So it's still 60 days. with credit for time served. I'm sorry. There you go. Just sign again. It's the exact same of what we went over before.
Outcomes is just what matters.
Yes. Okay. Thank you. Okay. Yes. If I may approach.
All right, sir, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, is it Sawzak?
Yes, sir.
Okay. 24 CF 2627, I've been handing a plea and sentencing agreement, excuse me, for you to plea as charged possession of controlled substance, 5-year maximum is a third-degree felony, and possession of drug paraphernalia, 1-year maximum is a first-degree misdemeanor. Calls for you to do 60 days jail concurrent between the charges and credit for time served. Is that what you want to do today?
Yes, sir, it is.
All right. Did you go over this plea form with your attorney, Ms. Flowers?
Yes, sir, I did.
All right. Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did she answer all of your questions if you had any?
Yes, sir, she did.
And are you satisfied with her advice and representation?
Yes, sir, very much so.
Okay. And you had filed something a couple of weeks ago saying maybe not.
Yes,
but-
sir, it was a misunderstanding, and that's been clarified.
And I read it, and that's the way I took it, is just
Yes,
when your
sir.
court dates go and how they operate. So that's the way I understood it as well. But no concerns with representation or advice?
No, sir, I'm happy.
Okay, that's what you said. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Any mental health issues or concerns? Did anyone force, pressure, or threaten you in any way to enter this plea?
Sir, they did not.
Anybody promise you anything in return for your plea?
No, sir, other than the plea agreement.
Okay, they promised you 60 days?
Yes, sir.
Okay, and I'm sure they'll live up to their end of the bargain. All right. You understand there won't be a trial of any kind if you enter a plea?
Yes, sir.
And you read about all your trial rights that you'd be giving up in order to take the plea?
Yes, sir.
Any questions about those? And you understand you're waiving any potential defenses that you may have to both charges?
Yes, sir.
All right, and what is your plea?
Guilty, sir. Oh, I'm sorry, no contest. I didn't know it was.
I heard no contest. All right, I'm going to accept your no contest plea to both counts as freely, voluntarily, knowingly given, and adjudicate you guilty on both 60 days credit for time served, 60 days jail with credit for time served, $615 in court costs, $150 cost of defense. And then those will go to collections. Is that what you want, Mr. Sawzak?
Yes, sir.
Okay. All right. Step over and be fingerprinted. You've got 30 days to appeal the judgment and sentence of this court. This is a
Downward departure, Judge.
downward departure. We scored 38 months.
Yes, sir.
Okay. State's agreement?
Yes.
All right. All right, go ahead. 60
Thank
days.
you, Your Honor.
I
Thank
believe
you.
that's all I have today.
Thank
you.
All right.
Thank you.
Thank you.
All right, Judge, this is going to be a negotiated plea to 6 months county jail with credit for all time served, $100 cost of prosecution, and then $150 PD fees. Send outstanding monies to collections. I have explained to him how he can request to get on a payment plan with the clerk. Get your signature right there, sir. That's what you're looking for. And again, Judge, there's no pass-through back there where I can give it to him.
Oh, I know.
He was in court when I went to see him yesterday.
At least I have the glass here you can see through, not like the South End. That screen, that's just. You can see or you can hear, you don't get both.
Yeah, today's the 6th. 25. Okay.
After this? We have a pretrial detention hearing at 12:30.
Yes, Your Honor, 12:30.
Judge, Mr. Kilpatrick. Trial detention.
Yeah, it is the attorney of record.
All right, Mr. McNab, can you raise your right hand, please? Mr. McNab, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your name and date of birth, please? Can you pull that microphone over for him?
Ladarius.
I can hear you, but I want to make sure. Sometimes the microphone doesn't pick it up very well, and it didn't look like it was. All right, you're here in 24 CF 2134. You can put your hand down. Did you go over this plea agreement on your violation of probation with Mr. Williams?
Excuse me?
Did you go over this plea agreement with Mr. Williams?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Okay, and it calls for you to do 6 months in county jail. Is that your understanding?
All time. Credit time, sir, right?
Yes. All right. Did Mr. Williams answer all of your questions?
Yes.
Are you satisfied with his advice and representation?
Yes.
Are you under the influence of any alcohol, drugs, or controlled substances?
No.
Do you have any mental health issues or concerns?
No.
Anyone force you to do this?
No.
Anyone promise you anything in return for entering an admission to your violation of probation?
No.
You understand there won't be a hearing where the state will have to prove the violation if you enter an admission?
No.
You don't understand that?
Mm-mm.
Okay. So if you enter an admission, there won't be an evidentiary hearing where the state has to prove that you violated your probation. Do you understand? There's not going to be one of those hearings if you enter a plea.
Okay.
Like basically, there's not going to be a trial on your violation of probation.
Okay.
And you're admitting that you've violated in the way they've alleged. Is that right? Is that right, Mr. McNab?
Yes.
Okay, you can't just nod. You got to speak up. Do you have any questions about that?
No. No, sir.
Okay. So you understand this would be your last court date in this case?
Yes, sir.
Okay. And you're waiving any potential defenses that you may have to your violation of probation. Do you understand that?
Yes,
Mr.
sir.
McNab,
Yes,
I'm
sir.
talking to you up here.
No,
You're staring at
I'm
his
sorry.
paperwork
I was
instead
trying to
of
read.
listening to the judge.
Yeah, I'm sorry. I was trying to read.
How much time does he have credit for time served?
Judge, I want to say.
Ballpark. Because Mr. McNabb, if you don't want to listen to me, we can just call you back on another date.
Oh, I'm listening. I'm listening.
No, you're not, because you're not answering me.
Oh, you asked me how much time I have. I had like 4
There was a
months.
question before that where you were reading what Mr. Williams is writing instead of answering the question. I'm not trying to be difficult, Mr. McNabb, but you've got to pay attention to the questions. Do you understand you're waiving all potential defenses that you may have had to the violation of probation?
Yes, sir.
All right. And are you admitting or denying your violation of probation?
Yes, sir.
Are you admitting or
That I
denying
violated?
that
Yeah.
you violated?
Yes, sir.
You're admitting or denying?
Oh, no, I really didn't violate it, but you know what I mean? Because I haven't,
All right, do you want to come back for an evidentiary hearing on March 27th?
no, sir.
So are you admitting or denying your violation of probation?
Yes.
It's one or the other. You're either saying, yes, I did it,
Yes.
or no, I didn't.
Yeah, yes, I violated.
Okay. Are you sure about that?
Yes, sir.
Do you have any other questions that you want to ask Mr. Williams before you do that?
No, sir.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to revoke and terminate your probation, adjudicate you guilty, 6 months county jail with credit for all time served, $100 cost of prosecution, $150 in PD fees, send your outstanding money to collections. You have 30 days to appeal the judgment and sentence. Mr. McNabb, this is a guideline sentence. I'll need your fingerprints as well.
Thank you, Judge. All right, good luck, Mr. McNabb.
Mr. Russell.
Okay. It's a plea date case or arraignment case?
Yes, sir.
Okay.
Only 1:30?
Any clerk's issues with handling it now? Okay. Okay. You're Darren Scott Webster?
Yes, sir.
All right, Mr. Webster, you're here in 25 CF 37. You're a little early, but we'll take you. I've noticed you've been sitting back there for a while as well. I just assumed you were here to watch one of the other cases. You were set for 1:30, but we'll handle it so you don't have to come back. You're charged with possession of a weapon or ammunition by a convicted felon, as well as possession of a controlled substance. Those are both third-degree felonies, punished by up to 5 years in state prison each. Do you understand that? Can you afford an attorney to represent you in that case? All right. Do we have PD forms, the energy form up there? It's usually here for the 1:30. Do y'all have one of those?
I think there's an application form on the podium in front.
Nah,
All right.
Are there any in the
Grab some
podium?
by mistake, Judge. Hang on. Here we go. Yeah, I've got them. I grabbed them up with the rest of my paperwork.
All right, so Mr. Webster, what I'm going to do is you're going to have to fill out this form, just one of them. Go turn that into the clerk's office downstairs on the first floor before you leave here today. But I'm going to provisionally appoint the public defender to you based on them approving that indigency application. Ms. Rivers.
This time, we're going to enter a not guilty plea, request trial by jury, and
Set for pretrial conference April 28th.
28. Your Honor, would that be at?
That would be 1:30. Mr. Webster, 1:30. It's okay, I just don't want you to waste your whole day again.
I just state the offer for the record so that he has it, is to plead as charged. He's a convicted felon, and I'm asking for 2 years of probation with substance abuse evaluation and treatment.
This is not a minimum mandatory charge?
No, Judge, no,
Okay.
it's not.
Is it not a firearm, is that one?
It's either not, I don't know the facts, but it's either not a firearm or it was not actual possession.
Okay. All right. All right, do we have anyone else ready?
Here. Oh, a knife, there was a knife.
You can't make assumptions.
do Nolan Chesher?
I think we're waiting on him.
Oh, I can't remember. Yes. Yes.
Do we know the information on the pretrial detention? What is it? Larry Leonard. I think it was mistakenly put on Stone's docket. That's what I just don't have it anywhere where I can see it. So. Okay. Just because at this point we're not going to have a whole lot of time to do much. So. I got a sandwich if you want to split it. Probably. Maybe that's part of the problem. Maybe I should only eat half a sandwich.
Pass, and then also we can call out Mr. Dixon. I believe the state's been asked for a continuance. He's on your 2:30 docket. That's fine.
Hey, Steve, we've got new people. We've got new people. I'd like to eat my sandwich. Got a bunch of warrants stacked up.
Judge, this is Nolan Chesher. Case numbers for the record are 22 CF 1321 and 23 CF 54. On Mr. Chesher's cases, we thought we had worked something out, but we're not. We're not able to. So I didn't know if you wanted to pass this for a status or if you wanted to set it for a contested hearing.
I mean, I'll put on the next date. If you want it to be an evidentiary hearing, we can announce that now.
I think that the basis for the violation is that he got another driving charge in that misdemeanor, the CT case. Is that
Correct.
still outstanding? So I would probably just prefer to continue it and see what happens in the CT case.
That works for us, Judge.
All right, March 27th, 9 o'clock.
Your Honor, could I please
I'd
speak?
like to, but you might want to speak with your attorney first. Just don't talk about the facts of your case. I've got it.
Hold on a minute, Judge. He's thought about it some more.
My reading of the court minutes in the CT case says that he can take a plea in the CF case that involves that for 10 days jail.
That's correct, Judge, and that's what I've put on the plea agreement.
That's from his court date 2 days ago, Ms. Turner.
Yes, sir. And I believe we are asking the court to take jurisdiction of that CT case.
And again, I talked to Judge Ward this morning, and he told me, especially when it's in the notes, that I can certainly handle those for him.
And for the clerk's benefit, the case number on that other case is 25 CT Charlie Tom 41. And I have a plea agreement and a score sheet if I may approach, Judge.
Sir. All right, Mr. Chesher, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
Mr. Chesher, you're here in violations of probation in 22 CF 1321 and 23 CF 54. There's also the new case, which is a county court case, but we can handle that here today, 25 CT 41, where there's the two VOPs, and the new case is a driver while license suspended. Is that what you understand it to be? Okay. All right, the plea calls for 180 days county jail on your VOPs and 10 days on your new driving on suspended. Is that what you want to do?
Yes, sir.
Did you go over this form with Mr. Russell?
Yes, sir.
Did he answer all your questions? Did you read the form and understand it? Did you sign it? All right, Mr. Russell, can you just pull that microphone closer to him? I can hear him, but I'm just worried about the record is not hearing him. All right. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Any mental health issues or concerns?
No, sir.
Anyone force, pressure, or threaten you to enter these pleas?
No, sir.
All right. Anyone promise you anything in return for your pleas other than what this agreement says?
No, sir.
All right. And on your violations of probation, do you understand if you admit that you violated your probation, there won't be an evidentiary hearing where the state would have to prove how you violated your probation? Do you understand that?
Yes, sir.
Do you understand that if you enter a no contest plea to the new drive while license suspended, there won't be a trial of any kind?
Yes, sir.
And you're giving up your trial rights that are not enumerated in this. You understand you're giving up your right to have a trial, call witnesses on your own behalf, confront witnesses against you, and you're waiving any potential defenses that you may have.
Yes, sir.
Okay. And as far as the violation of probation, what plea are you entering there? Are you admitting or denying?
Admit.
All right. I'll accept your admission to the violations of probation as freely, voluntarily, knowingly given. As far as the new case, 25 CT 41, are you pleading guilty, no contest, or not guilty to that charge?
No contest.
All right. I'll accept your no contest plea as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty in the violations of probation, revoke and terminate your probation, 180 days county jail on each count, concurrent credit for all time served, $200 cost of prosecution, $250 PD fee, money owed to judgment. And then the new case, 25 CT 04, adjudication of guilt, 10 days county jail, concurrent credit for time served, court costs, $100 PD fee, and that money owed to judgment as well. You understand all that, Mr. Chesher?
Yes, sir.
I'm going to need your fingerprints. You've got 30 days to appeal the judgment and sentence. Was this a guideline sentence and state's agreement?
Yes, sir.
Okay, thank you. Oh, 300. I said court costs. I didn't say the amount, so 300 court costs on that. All right, thank you, sir. I should be more specific. $300 court costs on the CT case. I know you said it, Madam Clerk, but it might not have been picked up by the record, so I should say it.
Judge, this is Rico Daniels. Case number is 24 CF 2584. If I can just have a moment.
Yes, sir.
Judge, I have a plea agreement, a score sheet if I may approach.
Daniels, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right. You're here in 24 CF 2584, which is counts of burglary, unoccupied structure, and criminal mischief, both third-degree felonies. Do you understand that?
Yes, sir.
Both are punishable up to 5 years in state prison. Excuse me. That one was building. All right. You understand 5 years in prison for each count possible, right?
Yes, sir.
All right. And this is a plea and sentencing agreement that calls for 120 days in county jail. Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea form with Mr. Russell? Did he explain it to you?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did he answer any questions you may have had? And are you satisfied with his advice and representation in this case?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Any mental health issues or concerns?
No, sir.
Did anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything for this plea?
No, sir.
You understand by entering a plea, you're giving up your right to a trial and all the trial rights that are listed in this form.
Yes, sir.
Did you understand those?
Yes, sir.
Okay. All right. And what is your plea?
No contest.
All right. I'll accept your no contest plea is freely, voluntarily, knowingly given. Adjudication of guilt on each count, 120 days county jail, each count concurrent, credit for all time served. Court costs would be $515 court costs, $150 PD fee, money owed to judgment. There's a $300 restitution to the Westside Church of Christ. Is that going to be a civil lien?
Yes, sir.
All right, civil lien on $300 restitution to be paid to Westside Church of Christ. All right, anything that I missed? State's agreement and guideline sentence?
Yes, sir.
Okay. All right, Mr. Daniels, you got to step over, be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
Judge, this is Aem Dixon, case numbers 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835, 22 CF 1506, and then those are all VLPs, and then a new law violation in 24 CF 1598. We were scheduled on your 2:30 docket for an evidentiary hearing. I think the state was going to ask for a continuance. They had a witness issue.
Yes, Your Honor. Probation Officer Johnson is not available. She was subpoenaed, but she's on leave currently.
Go ahead.
Your Honor, I wasn't even trying to really do no evidential hearing. I was hoping to plead out to you and get this over with and behind me. I have a tech that violated my probation.
Again?
A tech that violated my probation.
You have a tech?
It was a technical that violated
Okay,
my.
well, then use the full word.
Oh, technical that
violation.
violated.
I just didn't understand. I understand that we have certain lingo, but for the record, we got to make sure it's clear.
Yes, sir. I had a technical that violated my probation, and I've been dealing with this probation since 2018, Your Honor. The same probation. I'm just trying to get this behind me so I can move forward.
What's the score?
I was suspended sentence for 5 years.
His scores. I'm sorry, Your Honor.
What's the current plea offer?
The plea offer for resolving all cases would be 18 months DOC. For the court's information, the court, Judge Gontarek, imposed on him at the last VOP hearing a 60.1 months DOC suspended sentence, and he stated that that was going to be it. For the court's knowledge, I want to mention that the score sheet, right? Just the VOP points. He scored 66 points, just with the VOP, because he has multiple violations. My latest offer that I just extended this morning was for him to plead to the VOP cases for the suspended sentence, and I was going to dismiss the new law. That was my offer.
What's the new law?
The new law is possession of controlled substance.
I thought it was only a technical violation.
That ain't what violated my probation. I caught that charge after the.
So typically, there's an amended.
Yes, yes. While he was on violation status, he picked up the new law. So that also violated his probation in a material way. Other than that, he's got 1, 2, 3, 4, 5 technical grounds for violation, including absconding from supervision.
I didn't.
I also want to mention to the court that at the time that the 60.1 month sentence was imposed by the court, it was already a downward departure. I objected on the record because it was really an illegal sentence, but the court left it at that. So
Why wasn't it an illegal sentence?
because it was below the guidelines. So
Downward departure without a reason. That's what you're saying.
yes, basically yes. And also because it was a suspended sentence. Normally, the suspended sentence has to allow.
Yeah.
It should be.
Yes, sir.
Normally.
Yes, sir.
Slightly more than what the person scores at the minimum, but this was even below what he scored at the time. So right now.
So he scored
I
a
don't.
significant prison sentence,
Yes.
and the court gave him a suspended sentence for a lesser amount than that.
Yes. Yes. And now basically we're stuck with that, on a VOP, and that's all I was asking. I was asking that the court imposes the 60.1 months, and in exchange for that, withdrawing, going through with the hearing, I was going to dismiss the new law.
Well, Your Honor, the only reason I ended up with the 5-year suspended sentence, they offered me 24 months for my VOP, but she wanted me to waive my time, and that was our argument, and that's why Gunterric turned around and gave me the suspended sentence.
Judge Gunterric.
Judge Gunterric gave me the suspended sentence because she wanted me to waive my time when she offered me 24 months for it, and I accepted it, but I just didn't want to waive my time, Your Honor. I was entitled to that time.
Okay.
I wanted to take the deal. I wanted to take the plea, but that was the argument against it. So that's when Judge
But you have the
Gunterric,
suspended sentence now.
that's when Judge Gunterric gave me the suspended sentence.
I understand.
Yes, sir.
That's the history of the case, but the case now is you're alleged to have committed numerous technical violations of your probation and have a new law violation.
I don't.
Be careful what you say. Say what you want to, but be careful what you say.
Your Honor, I can beat the other technical violations, the absconding. The only one I cannot beat is the dirty UA, and I can't beat the dirty UA. I went to seek help. I got into a schooling while I've been in jail. They accepted me into it. It was institution, and that's what I've been trying to get out and go to this program and do something with myself. But yeah, 5 years. I shot him 36 months. I asked for 36 months.
I'm not engaging in a negotiation
Yes, sir.
with you, Mr. Dixon. I just wanted to know what the plea offer was so I understood what the situation was, because it seemed like you were trying to get me to address it. I'll tell you, what it sounded like you wanted to do was plead straight up to the court. You
Yes.
can do that, but I'm not going to do a sentencing today.
Yes, sir.
Because I don't know all the issues, because I'm going to go back and look at what happened.
Yes, sir.
So you can either enter a plea today and we'll set it off for sentencing, or we can reset the evidentiary hearing for another
I like
day.
to set a plea.
You want to enter a plea now,
Yes, sir.
straight up?
And Judge, before we go down that road.
Is that going to
'cause-
be on the new law violation as well?
I would rather just take the.
I understand what you'd rather do.
Well, however you want to do it, then, Your Honor.
Well, you either going to enter a plea of guilty, no contest.
No contest.
Hold on. Okay. You've got to let me finish.
I'm sorry.
Because I got to tell you certain things, and if you interrupt me and I don't get back to it, then I may make a mistake, which I'm trying not to make. So, if there's going to be a plea straight up, it needs to be written up. So we can come back this afternoon when you were normally set, if you want to do that. But it's up to you if you want to enter an admission to your violations of probation, and if you want to enter a plea on the new law violation. But understand, the new law violation is not part of the suspended sentence. So that if you enter a plea straight up to that, you could get 5 years on that as well. Do you understand that?
Yes, sir.
And you understand those can run consecutive, which means you could potentially get 5 years and 5 years.
Yes, sir.
Okay, if that's what you want to do, Mr. Russell will write up a straight up to the court plea, So I want to make sure you've gone through all those rights and you understand what you're doing, and we'll resolve it this afternoon that way. But I'm not going to do a sentencing hearing today because I don't know all the facts. As you talked about, it was another judge who sentenced you previously. Anytime I'm going to sentence somebody, I have to familiarize myself with the case.
Yes, sir.
And I can't just do it off the cuff, not knowing what the previous issues were, because that seems like there's a lot of disagreement about what happened previously before I took over this case in this division. So I'd have to spend some time reviewing those things.
Okay.
All right. So I'll let you think about that, talk to Mr. Russell about it, and we can handle it this afternoon.
Okay.
All right.
Thank you, Judge.
Can I see him in the back, please?
Do we have anyone else? Oh, okay. They tracked you down, Mr. Berry.
Hard to find.
All right. Who's handling the pretrial detention?
I'm sorry.
Are you handling the pretrial detention hearing?
Yes, I am.
Have you had a chance to talk, without telling me any discussions that you've had with Mr. Kilpatrick, have y'all talked about what you're going to do with it? Is it going to be a hearing?
Yeah, it's gonna be a hearing.
Okay.
Yeah. I have a
I'll just, if
witness.
there's going to be no hearing, then I would maybe say let's come back at 12:45, so we all
Sure.
have time to eat, the entire bag of chips that we're talking about.
Yeah, no, he plans on coming.
Okay,
this
I just want to
afternoon.
make sure. So we'll be back at 12:30. That's only 24 minutes from now.
That's fine, better than nothing.
Well, I just don't know how long the hearing's going to be, and I don't want to then start pushing into our 1:30 docket, which is then going to push into our 2:30, and then next thing we know, it's 6 o'clock.
Yeah.
So if Mr. Kilpatrick gets here and y'all have worked something out,
No.
please make, okay. Because I don't want to talk anymore about the case. I'm familiar with
I
what
got
it
it.
is, because it was something that was served on him last week, right?
Yes, Your Honor. I just want to mention that and he knows, I'll have one witness, law
have a
enforcement
witness.
for the hearing.
Okay. All right, then we'll be back at 12:30.
Yes, sir.